morning. The time is now 10 o'clock. Today is Friday, May the 5th, 2017. This is a meeting of the Texas Appraiser Licensing and Certification Board and has been duly posted. Our first item on the agenda is the call to order and the pledges of allegiance. If you will stand and join us.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Honor the Texas flag. I pledge allegiance to thee, Texas, one state under God, one and indivisible.
Thank you. Our next item is roll call and discussion regarding possible action for anyone that may be absent.
Chair Jamie Wycliffe.
Present.
Jim Jeffries.
Present.
Buster Renfro.
Present.
Clay Platt.
Present.
Jeff Bolton.
Present.
Tony Pena.
Present.
Martha Gale Reed Lynch.
Present.
Alex Solstrak.
Present.
Joyce Unison.
Present.
Oh, congratulations. We have a full house. Item number 3 on the agenda is recognition of retiring PIC members, mentors, and departing AMC Advisory Committee members. If any of these parties are in the house, we'd love for you to join us at the podium. I haven't seen anyone, but Mr. Pearson, Mr. McNamara, Mr. Pistilli. Seeing none, I'll just make a couple of comments about these folks and their service. We have some appreciation items for them and look forward to having an opportunity to personally tell them how much we appreciate what they have given this organization. Mr. Pearson has served this organization, I believe, since its inception. He's certainly been around and active as long as I've been around. I believe he's retiring after quite a number of years, but certainly has served most recently as both a PIC member and as a mentor. I think those terms of service have been 4 and 5 years in their length. So, Mr. Pearson, hope you're listening to us at home. We very much appreciate your leadership over the years. Our AMC Advisory Committee members, Mr. McNamara has been around a long time as well. He certainly was serving on AMC when I had the opportunity as vice chair of this organization to serve on that committee, and he did an excellent job. His presence and his comments were always appreciated. I believe he's moving out of state to Denver, and so the great state of Texas will miss his service. And Mr. Pistilli, I think, is taking a different job and makes him unavailable to serve our organization. All of these folks, great leaders in our industry, and we appreciate very much their service. The board would, if any of you have a personal relationship with any of those gentlemen and would like to make comment, the floor is open for you to do so. Hearing none, thanks again, guys. We'll move to agenda item number 4, which is comments from the members of the public regarding non-agenda items. I'll remind the board we'll receive information at public comments and allow presentation. We do have 4 individuals requesting, actually there's only one public comment, my apologies. The other individuals are requesting comment on specific agenda items. Mr. Baer is in the audience and would like to speak to you. Mr. Baer, if it's possible for you to speak within a 5-minute time frame, that would be appreciated. If it's not, just let me know and we'll develop it along the way.
Would that include also any questions
No.
might have? Okay.
No, sir. I'll certainly allow you 5 minutes to present your comments.
And if you don't mind, I have some materials and exhibits that I don't think are part of the record that I'd like to hand out to the board.
It's fine with me. You'll have to ask. If you'll hand them to counsel, she'll look at them and pass them out to us.
These are agenda item 4 as well.
Does he actually have an agenda item 4? Oh, they are. Gotcha. So I'll bring them. Sorry. And I did, while Mr. Baer is getting organized, I misstated an item just a moment ago. There are the other two agenda items, or other two public comment items are public comments, and I will open you with an opportunity to make those comments in public in just a moment. Don't know. We don't have any substitutes. When we get to your committee, we'll give you an update. So when we get to ORC report, probably not listen to this and go. We need to tell Mr. Jeffries who's on his committee.
Happy to do so.
Because I
Talk
think
to the
he's,
governor's office
I think he's serving alone.
Thank you.
Share. 'Cause it doesn't. No, you're good. Doug and I'll share. Yes, we're fine. It appears we have enough for each board member. I was just looking to see if the commissioner had a copy. If he doesn't, he and I will share.
Ladies and gentlemen, good morning. Thank you all for entertaining my issue. Briefly, the materials that I passed out have to do, their background, and I strongly encourage you to go through them as members of the board and not necessarily dealing with staff issues each and every day. I think it's instructive to the process that the TALCB has gone through, my experience with the TALCB with respect to an agreed order, and in particular that agreed order is number 15069. I'm not here to relitigate that agreed order. It is a settled item. However, first and foremost, I'd like to point out that the agreed order, and you'll find that on tab 3. Specifically, there is no admission of any wrongdoing that's under the conclusions of law, no violation of use path. However, on the TALCB's website, prominently, when you look up disciplinary actions, is my name, and also I'm here on behalf of another gentleman, another appraiser, Mark Sykes, who's had the same thing happen with him. But if you look and on that tab, I'd like to point you to tab number 14 and 15. 14 is specifically mine, but this is what happens when you go into the website. At the very bottom of the link, when you type in my name, it has the basis for order, and it prominently states respondent violated use path. That is false. I did not violate use path. I did not agree to violate use path, and I strongly dispute that. So that's wrong. My attorney in this matter, Don Griffith Jr., has reached out to the TALCB through emails. That's also included in this packet. And we got a reply that, well, we'll look into it, but don't worry about this because there's a PDF with respect to your agreed order. You can drill down that PDF and someone will then know that you didn't violate use path. That's not the case. That's not acceptable. That would be like me putting a sign up in someone's yard that says feet inside, but they would need to knock on the door and ask and to verify that. That's misleading, and to expect the public to go in and drill into that website and read the legalese and come to the conclusion that I didn't violate use path. I'm very passionate about this, and I feel strongly about it. So I would respectfully but expeditiously ask the board to look into this and get this changed. because I do a lot of work that involves litigation support. I do condemnation-related work. I've been doing this for 30 years. I have a Bachelor of Science degree in real estate in MAI, which I've had since the age of 28. I'm a past president of the Houston chapter of the Appraisal Institute. And essentially, and I do encourage you all to look into this again, I was filed on, as was Mr. Sykes, in order to gain advantage in a condemnation case. And that is clearly stated in this. The TALCB knew about it. They proceeded anyway. They, the reviewer, who I didn't consider to be a peer, essentially threw the book at me. All of that is laid out, and in the interest of time, money, and expense, I did agree to settle this, but I didn't agree to any wrongdoing. So I would certainly like, at minimum, the basis for the order on the website to be removed. In addition to that, and just as editorial, I don't think it's the proper, and if you'll go back to the initial 2 pages, 3 pages of my letter, I don't think it is the proper scope or purpose of the board to be inserting themselves into matters of litigation. In fact, in this matter, there was a file that I had to produce that cost $1,300 of about 8,000 pages. There were voluminous depositions, 3 appraisers on each side, or at least on the property owner's side. And I hate saying that, I just performed a value. 1 appraiser on the behalf of the condemnor, but nonetheless, a gentleman was brought in who I don't consider to be a peer, who clearly did not look at the file, the depositions, much less my responses, or couldn't have, or was negligent in doing that. And the TALCB dug their heels in and decided to pursue this in a, I think, in a very harmful manner to me, and I take it very serious. I've been in this profession, again, a number of years. I'm very proud of my accomplishments, and up to this point, I have never had a complaint filed against me, much less anything on the order of what the TALCB alleged. But this, it should be informative and instructive reading for the board, nonetheless, because I know you all get those agreed orders, you look through them, you assume that the case has been handled, but in reality, there's probably a story behind that. There certainly is behind mine, and I want to present that to the board and have the board visit that. So with that being said, I'm here with a mind, definitely a purpose and intent to try to get, and I would like to get, at minimum, again, the basis for the response portion of the website removed that says respondent violated use path. That's defamous. I think it's libel, and it's just false. It's wrong. It needs to be changed, and it needs to be changed now. And moreover, I really would like the board to go in at some point, consider my case, consider the position of the TALCB, typically inserting themselves in a heated condemnation or litigation matter where you have numerous appraisers, you have voluminous witnesses, testimony given, and moreover, and I'd just like to finish with this, in the trial itself, the jury came in on a number above mine, in fact, and the case was appealed. After the trial verdict came in, the complainant filed on me. And prior to the jury trial being concluded, that complainant filed on Mr. Sykes. Nonetheless, the TALCB inserted themselves, went forward, inserted themselves in the place of the judge, jury, the experienced condemnation lawyers involved in this matter, and came to their own conclusion, which I think is just woefully wrong. It's not their place. This case was also appealed to the 14th Court of Appeals. It was upheld, it was affirmed, it was also then appealed to the state Supreme Court. And I have those tabs in there too. And just this March, it was denied, was not heard. So I have been affirmed on my value. I know what I'm doing, and my report it is stellar. In fact, I had Mr. Ratliff, James Ratliff, who many of you all know, reviewed the report on behalf of me in proceeding prior to the agreed order. In fact, he liked the report so much he called me recently on behalf of the Texas Municipal Board to have me bid on a project, an appraisal of some property they have, 10,000 acres in Grimes County. So
Mr. Bear.
I really think I've been wronged, and I appreciate you all's thoughtful consideration with respect to the attackers.
And I appreciate your comments and don't want to cut you off. I just wanted to make note that I've given you twice as much time as I had asked about, so I'm good with that. Let me be sure that I understand your request. I understand your request to be that you'd like us to look into correcting the discipline as it's represented on our website.
Yes, ma'am.
Okay. All right. Thank you.
In addition to that, just thoughtful perusal of
Sure.
the attackers. Thank you.
Thank you for your comments. Mr. Becker, do you have a preference? Would you like to speak first or your attorney first? Okay. So, Mr. Walden, if you will, state your name and...
Yes, thank you very much, Chairman Whitler. I'm Don Walden. I'm an attorney in solo practice here in Austin, and I've, for a number of years, I've represented quite a few appraisers in disciplinary matters and licensing matters before the board and in contested case matters. And I'm here on behalf of, today, my client Ken Becker, who's in the dark coat there behind me. This won't take long. We're here, and Ms. Wycliffe, you and I had a brief communication about this a couple of weeks back, but Mr. Becker had an agreed order. There's been what I believe is just a very honest misunderstanding out of that has caused him some drastic consequences. It was his second agreed order he's entered into in his career. What happened with the first one is very critical to where we are today, and that is that the agreed order that he entered into some years ago said that he should attend a live continuing education course as one of the conditions, and after that he took an online McKissick, I believe is the provider, class 2 or 3 years ago, and that was accepted by the board as complete satisfaction of the terms of the agreed order from a couple of years ago. I represented Mr. Becker in the negotiation of a second matter that came about here, and we resolved it last year, and it had the identical requirement in it that you attend a live class. And as he did 2 or 3 years ago, he did an online course. And then this time, though, what happened differently was that wasn't accepted, and the staff notified Mr. Becker that his license was suspended, and that was on March 3rd, and his license remains suspended today. And so, and there's also a requirement of a $1,000 fine that's been imposed upon him for, the notice says, failing to comply with the agreed order that required not an online course but an in-person attendance. And I spoke with the board's very capable attorney, Troy Bollier, about this, and he suggested that I told him I wanted to address the board on behalf of my client, and he suggested that I appear in the public comment, which is what we're doing here today. And so I think, Mr. Becker has also gone out, and even though it was a 7-hour requirement, the only live one he could find in the state of Texas in the next month or so was a 28-hour one, which he paid for and completed, even though it was 4 times what was required. The provider wouldn't allow him to just attend 7 hours, and unfortunately, unlike the way it works with the state bar, the 21 extra hours don't carry forward to the next reporting session. So, but he needs to get his license back, so he did it. And the main request that I have is that given the unique set of circumstances that the first time he did this with the identical language in the order, the board accepted, or the staff accepted, an online course. It obviously told Mr. Becker that that's an acceptable thing to do. And what I'd like to do is ask that the $1,000 fine for noncompliance with the order allegedly be waived and that Mr. Becker's license be reinstated. It's a unique set of circumstances. I'm not asking for a broad sweeping change in policy. I spoke with Mr. Boyer and I did not represent Mr. Becker in the prior agreed order matter, and Mr. Boyer just indicated, as I recall, and if I state it incorrectly, I'm sure he'll correct me. He likes doing that. That it was just a mistake, an honest mistake, which that's understandable. That happens to all of us. But it told Mr. Becker that that's okay to do an online course, and that's what he did, and this time it wasn't allowed. So I think given that it's a unique set of circumstances, and I think Mr. Becker can also address the prevalence, as a going forward matter, there are, as I understand it from my client and others, that there are fewer and fewer live courses out there. Things are going more to the internet. So, and this has cost him, he has not been able to do business for a couple of months now. It's cost him $10,000 a month or so in lost revenues. So he's here today to address anything that I've overlooked or to answer any questions any of the board members may have, as am I. And I'll defer at this point to Mr. Becker, and he can say what he wants. And I'd like first, though, to answer any questions any of you all may have.
Mr. Walden, just a comment for the record. You did reach out to me, and I believe I redirected you back to staff and/or this board.
That's correct.
Okay, just for the record. And
Good clarification.
are there any, keeping in mind, you can ask questions that we'll talk in a moment, and we'll ask General Counsel to give you advice and potentially Mr. Boyer as well to weigh in on comments from the staff level about actions on items that aren't officially on our agenda. So I'll ask in a moment when the parties asking for public comment have fully informed us all they want us to know, be aware. I'm going to be then turning to our legal counsel to ask for some clarifications. So I don't have any specific. Does any of the board members have any questions about what's gone on or what's been presented thus far? If not, Mr. Walden, we'll hear from you. I'm sorry, not Mr. Walden. We've just heard from you.
Thank
Mr.
you
Becker.
very much.
Yes, thank you.
Hello.
Just one request I have is if you people could please change the wording in the final order so my peers, my fellow appraisers, don't fall into the same expensive venture that I did. Like Don said, the internet class was accepted the last time. I searched extensively for live classes, and they're on the education providers on the TALCB website. There are zero. There's no 7-hour income approach classes offered anywhere in the state of Texas. I called 5 of the providers, and they said there's just no interest. So go take a McKissick course, which is exactly what I did. And it was accepted last time, and I was just a little confused why it wasn't accepted this time. And I wanted to be compliant with the board, so I did it within the time frame, and then 2 days later I get a notice that it's not accepted. So I was just curious as to why.
We'll see if we can't get you those answers. I will share your burden of having attended a 28-hour course one time for my license renewal when I only needed 7. Got to fly to Houston and do it over a Christmas holiday because I did not realize that the course that I had taken wasn't acceptable at the time. So I recognize that it does happen in the real world. I've had that experience for different reasons myself. Any other comments you'd like to make to the board?
That's it.
Let's see if we can get a little bit of input now. See what, if anything, we can do. Thank you.
Thank you.
Troy, would you like to give us any background that you have from a staff perspective as it relates to the communication you've had with this issue?
Yes, ma'am. Good morning, board members. Troy Bollier, Director of Standards and Enforcement Services. And basically, the background is Mr. Becker did submit close to the end of the time period for submitting his remedial education on that second agreed order. He did submit a course completion certificate, but it was for an online course. And the order in a couple of different places does require in-class attendance. And so, as we do with all compliance matters, we notified him in writing. We have a standard process and a standard notice letter that goes out when someone is not in compliance. And we also reached out and provided available offerings. The unfortunate part is obviously we at the agency as staff don't have control over what course providers may offer during the course of 6 months, 9 months, 12 months, depending on how much time in a particular disciplinary order someone has to complete the course. I did go back and make a diligent search because we obviously keep track of what courses are available over the time, and there were offerings available prior to that over the course of the previous year. So I think one thing to keep in mind is, are we talking about a situation where someone started looking for something right after they got the order and they literally couldn't find something all year? And we've had those situations, I think, before where people have come before the board while they are in good standing and have asked for an extension and been granted that, because obviously courses may get canceled, that kind of thing. In regards to the prior order that Mr. Walden mentioned, he did bring that to my attention once he got in touch with me after the suspension had gone into effect, and it did appear that there was a clerical processing error at some point several years ago on that prior order, and so it looks like an online course was granted credit when technically it should have not. But that's really all the additional information I have. Of course, I'm happy to answer any questions you might have.
Before we
Chair.
go very far there, I'd like to just say, on previous comments, based on my understanding of the process in public comments, the board can't take action. Now we've just heard an issue or concern of someone whose license is actually suspended, which causes me now, I'd like to turn to general counsel and get some input and at least a public explanation of what can this board do today as it relates to either of those issues that have been presented in public comment.
Unfortunately, Madam Chair and board members, the board cannot take action today because neither of these issues were brought to the board to be placed on the agenda. And because they're not on the agenda, to take any action on them would violate the Texas Open Meetings Act. Okay. What the board's options are include referring this to a committee. The committee could look at it post haste and get a recommendation back to the board, or the board could delegate to the committee to take action on these items on behalf of the board. But those are the options available to the board.
So let me ask you an additional question. Based on the fact that Mr. Walden did call me, and based on what I understand was proper action, I directed him back to staff and or this board. I've informed him I couldn't give him any help individually, but that he could reach back out to staff and get some input. Is there any reason his issue, because it was brought forth to both myself and the staff, is not on our agenda?
Yes, Madam Chair. According to the board's rules, a matter like Mr. Becker's cannot be placed on the agenda because his license is currently not in good standing. And the rule allowing this board to modify an agreed order requires that the respondent contact general counsel, myself, at least 14 days prior to the board meeting, which was done in this case, but at the time, the individual must be in good standing to request the modification. And at the time I was contacted, Mr. Becker's license had already been suspended.
Okay, so it sounds like there was a 48-hour period of time from the time that he took whatever action he took and he received notification from us. In other words, when he got the mail, was his license already suspended? When he got the mail notifying him that, hey, Houston, we have a problem, was his license already suspended so that he couldn't have taken these actions?
Madam Chair, this is Troy Bullier again. I can address that. We have a very specific process for compliance, and so we have a standard form letter that goes out in advance notifying an individual if they are out of compliance, and they have 3 business days to notify us if there is some unusual issue, like I mailed it in but it got lost, and that they can provide documentation to show they made that effort. So it's not until we've actually provided someone notice and gone through a process, had a dialogue, that we take any action. And then, of course, after we've gone through that process, they get another letter informing them, okay, now that time has passed and your license is being suspended. So it's a very formalized, very specific process that makes sure we give notice to somebody before we obviously do something like that.
So in order for this individual to reach a position where they could begin or be reinstated, what needs to happen?
Well, my understanding, and I have not reviewed the specific terms of the order, but that Mr. Becker's license could be reinstated with a payment of the $1,000 fine because he has completed the course. And this board has essentially given the respondents the keys, if you will, to rectify any suspension of their license when they do not comply with the terms. All they have to do is bring themselves into compliance with the terms of that order.
So the request has been twofold. One, to remove the suspension, which essentially the actions, with the exception of the $1,000 fine, have occurred. And again, I just want clarity, right? It's a bit confusing. So if he were to pay the $1,000, would that put him in a position then to come and ask that that be refunded to him because he thought it was unfair, or is that beyond the scope of what would be allowed because it's an agreed order?
No, he could certainly come back to the board after paying the $1,000 and ask the board to refund that payment based on this misunderstanding. And then at that point, the board could fully consider whether he wants to do that, or whether the board wants to do that, given the history of why this board has that $1,000 penalty to begin with.
Right, and I'm not saying that we would, right? But just simply that we would then have the opportunity to hear the issue.
Correct, yes.
Okay, thank you for the clarification. It's a bit confusing when you sit here and don't deal with it every day. What other questions does the board have? Oh, I'm sorry.
I'm sorry, and I don't mean to be presumptuous. I wanted to be able to address one thing that I think requires a response on my part, in response to the comment that we're here in a public comment as opposed to in the context of an agenda item that has been noticed. We're here in this context because this is what the TALCB staff told me I needed to do. I was prepared to file an application under the board rule that says my client's in compliance for the reasons I've explained, and we want this taken up and the board order modified according to the terms of the board's rule. And I was told by the staff that no, I can't do that. The only way I'm going to be heard is to come and appear for public comment. So I think it's a little unfair to say I followed the wrong procedure to be asking for the relief I'm asking for.
And I appreciate the comments.
Thank you.
I thought they were made clear by counsel, but the extra emphasis is probably helpful.
And the process is not appropriate. The process that you're asking to apply for a modification was not valid at the time you requested it because Mr. Becker's license had already been suspended. So under the board's rule, an application for modification did not lie at that time.
And just, I thought it was wrongfully suspended, so you can have that kind of argument all day, I guess.
And I appreciate that. It seems to me, based on the black and white explanation that we appear to be receiving, is there's only a single path that would allow you to, at least with the board in a position, to be able to have a voice. Is that correct?
Yes, Madam Chair.
Is it clear to you what the path is? Because I don't want you to be delayed unnecessarily any further. I guess I'm speaking to the...
I'm sorry.
Yeah, it's my understanding that the only way we can actually provide you with the relief, that at least consideration of the relief that you're asking for, is if you get him into compliance so that we can then
Pay the
address
fine.
it.
And then ask for a refund?
That's what I hear the rules are, and I got to tell you, I can only follow the rules.
And I asked for a little roadmap. To whom should the request for refund be addressed?
General Counsel, can you answer him? Or one of you that knows?
You can address it to me, to my attention.
Thank you.
Are there any other individuals that would like to make public comment to this board that have not yet filled out a form? You're certainly still welcome to do so. Seeing none, we'll move to agenda item number 5. Well, the actual consent agenda, which will include agenda items number 5 and 6, A through D. But in doing so, in moving to the consent agenda, I want to point out something to the board. The consent agenda is intended to enhance the efficiency by providing approval on a number of items with a single motion. Board, please be aware that in the past we've held an executive session in advance of your agenda items number 6 related to final orders and surrenders. So if you have questions or concerns about those items, they need to be removed from this consent agenda for action later in our agenda in order for you to be able to have conversation. We've moved those items in hopes that your general questions as they relate to agreed orders and whatnot would occur here in a public setting, rather than it appeared that there was a feeling that they were beginning to be asked in executive session exclusively. The public didn't have the full benefit of the board's vetting of any generalized questions they had on agreed orders. That being said, the consent agenda is open for action.
Madam Chair, I'd
Mr.
like
Chair.
to move that we remove item number D from the consent agenda.
6D, I assume?
6D, thank you.
6D will be moved. Any others? Hearing none, the floor is open for action on the remaining consent items, which are, I'm sorry, for the record, which are the ratification of the official record of the board on February the 9th, 2017, and agenda item 16-121 complaint, which is, and complaint number 16-158 and complaint number 16-133.
Madam Chair?
Mr. Jeffries?
I move that the board ratify and approve items, all items except number 6D on the consent agenda as presented.
Second.
We have a motion from Mr. Jeffries, a second from Mr. Pena. Any discussion? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. Item 6D, Mr. Jeffries, do you want to open that item for any general questions?
Thank you, Madam Chair. I got, as I read through this agreed final order, I got a little confused about the procedure that...
Hang on just a second, Jim. We're not sure your mic's on. Can you try it again?
Madam Chair?
That's better. Thank you.
Sorry. Thank you. As I read through this agreed order, I got a little confused about the procedure that the staff went through on identifying and citing violations in the 4 different properties that were addressed in this agreed order. And I'd like to have the staff tell me, or tell the board rather, exactly or explain to me how this particular complaint came to the attention of staff.
Yes, sir. Board members, Troy Bollier, Director of Standards and Enforcement Services. The agreed final order you have before you today is the result, as you can see on page 39, of 3 different complaints comprising 4 different properties. So one of those complaints involves 2 properties. They're all residential properties, and I believe that at least one of the complaints was filed by a consumer. One was the result of an experience audit, and one was opened as a result of a referral from a financial institution. Each one of these went through the normal complaint and response process and was investigated by the same investigator. And then, as you can see on starting on page 40, each one of the properties and the corresponding complaint number is kind of a subheading, and the specific violations related to those that were found. And of course, Mr. Diamond was represented by counsel in this matter. I don't believe his lawyer signed off on the order, but he was represented by counsel, and so this order was negotiated through his attorney.
Troy,
Yes, sir.
I guess my thought was somewhat the sequence of events that occurred here. Did we get a complaint from either a consumer or a lender prior to the initiation of complaints by the board?
Let's see. I believe that
It appears so, based
Yeah.
on this agreed final order, that a consumer filed a complaint in December
yes.
of 2016, and the board's complaints predated that. That's why
That's
Mr.
correct.
Jeffries is asking you that question.
That's correct. So, and this is not uncommon for, during the course of another pending complaint being investigated, for another one to be received. That sometimes does happen. And so then typically, unless there's some reason not to, that would be assigned to the same investigator for consistency purposes.
So how would the complaint have initially started? Was it a audit that caused the board to be in possession of the reports?
Well, each one of these complaints is independent of the other. So the complaint related to the audit that had two properties, that was the result of an audit, and issues uncovered during the course of that audit. Then separate and apart from that, the other two complaints came to our attention. So in other words, each complaint had an independent basis for arriving here.
Excuse me,
Madam
Troy,
Chair.
but I think the question or confusion may be, are you able to say the May 24th complaint was on this property and it was on the basis of an audit? The May 25th was on this property and it was on the basis of an audit. We received this next complaint on this date was from a consumer, and number 4 was on this date and it was from a lender.
Oh, I see.
I think that's the sequence we're looking for. Is that correct?
I apologize. Yes, so if you look at paragraph 2 in the findings of fact, you can see we've appraised 4 residential properties, and they're listed there. And then if you look in paragraph 3, you've got the corresponding complaint number that are received. So for example, 16-247 was received May 24th, and 16-247 would be the properties in Pittsburgh. Yeah, the property in Pittsburgh. And then we've got 16-251, and that was received May 25th. And that one is going to be the Sulphur Springs, the Northland property. So you can kind of, between paragraphs 3 and paragraphs 2, you can see which properties were associated with which complaint, if that helps.
But Troy, do you know which one was filed by the consumer versus the lender versus which one arose in the audit?
I think we can see that. It's just, there's a lot of data in front of us. I think we
Sure.
can see it in the written format, but there's a,
So the third complaint, 17-080, was filed by a consumer. 251 was filed by the board staff as a result from coming from a lender, and then 16247 was the one that was related to the, I'm sorry, I got that backwards. 16251 is the audit one, because that had two properties. If you look on pages 41 and 42. 16247 is the one that came from a lender, and 17080 is the consumer-driven complaint.
May I ask what the purpose of the audit was? Was that of trainees' hours?
Yes,
or-
ma'am. So, we have those experience audits that
Correct.
are regularly occurring. So this individual's trainee made application and went through the process and had an experience audit.
Thank you.
So Troy, technically, we have 3 properties involved in 2 complaints filed by the board as a result of an experience audit submitted by a trainee. During that process, a consumer filed a complaint on a separate property that was filed on December of 2016 for a property appraised in May of 2015. Does that kind of summarize where we are?
Almost. The only 2 of the properties were involved in the audit. The other staff-initiated property, the 16247, that was a result of referral from a lender. And then the last one, the 17080, that was the consumer-driven complaint. So only 2 of the properties are coming out of the audit.
But wouldn't a lender be a consumer? I'm confused now. I thought I had it figured out here.
No.
How many complaints did the staff initiate as a result of the experience audit? I think that's
Just one with 2 properties.
So one thing that might be helpful is the complaint that came, or the referral that came from the lender is listed here as the staff filed a complaint based on the referral. So it wasn't necessarily staff initiated, but 2 came from the audit, 1 came from a lender or based on a lender referral, although staff actually opened the complaint, and then 1 was a complaint filed directly by a consumer, correct?
Correct.
Okay.
Okay, I guess I'll take your word for it. I don't see that here. I see simply 2 complaints filed by board staff and a 3rd filed by a consumer. I think that's what I'm trying to distinguish. It gives the appearance, whether or not that's the case, that all the complaints filed by the staff were a result of this audit that we are now trying to read between the lines. And you don't really figure out some of this till you get further back in items 6 and 7. But in light of some of the conversation that's been going around and some of the meetings we've had, and what I'm hearing from some public members when I go out there, I'm just trying to get clear on these complaints resulting from experience audits. I know we've had a lot of correspondence. I know we've presented our numbers. I'm comfortable with that, but this would be one of those rare instances
Yes, sir.
mixed in with a consumer's complaint. Okay. Just wanted to be clear. Thank you.
And Madam Chair and board members, I just want to say that staff is working on the board's request to provide more clarity in these agreed orders as the board has directed. And that is a work in progress. And this order is something that was put together and finalized before that directive came down. And so we are hopeful that in the future meetings, as we work through this process, you will begin to see that clarity coming through in the orders.
Council, I'd just like to say I appreciate you working on that. That's something that I think would be very helpful for us as the board, and really helpful to what our mission is to have that clarity. And I look forward to that initiative going forward.
Are there other general questions that can be addressed to staff as it relates to this agreed final order? not, let me remind you, your options are, if you believe that there are additional questions that would be appropriately addressed in executive session, you have the opportunity to not act until we return from executive session. If you have no questions like that, then, which would speak specifically to legal counsel as it relates to this board, then you certainly have the right and probably should take action here unless you need legal input.
Madam Chair,
Mr. Jeffries?
I move that we agree to final order, which appears in our booklet as 6D, complaint number 16247, 16251, and 17080. I move that we approve that agreed final order.
Second.
A motion by Mr. Jeffries, second by Mr. Bolton. Any additional questions or conversation? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. We'll move to agenda item number 7, which is executive session to discuss pending litigation or receive advice of counsel pursuant to Texas Government Code 551071 and personnel matters pursuant to Texas Government Code 551074. The time is now about 12 minutes until 11 o'clock. We will go into executive session to obtain this advice of legal counsel and discuss the pending or contemplated litigation, including settlement offers and enforcement actions pursuant to Government Code 551071, and to discuss personnel matters pursuant to Texas Government Code 551074. We anticipate returning to open session in approximately 30 minutes. I apologize for my miscalculation. I seem to be good at shortening the time I think executive session will actually take, and I've never actually achieved that goal. But I'm going to keep trying. This time is now 12:05. The board is back from executive session and reconvening in open session. There is no official action to be taken from executive session. Next item on our agenda is agenda item number 8, the AMC Advisory Committee. That committee is currently chaired by Mr. Jeffries. Would you like to give a report?
Thank you, Madam Chair. If it please the board, the AMC Advisory Committee met on May 5th. We had all of our members were present. That included me, Jim Jeffries, Angela Guerrera, Lawrence McNamara, Sarah Oates, and Tony Pastilli. And we had a full complement of staff in attendance for that, on that conference call. And we also had a member of the public in attendance, Bill Owen from CoreLogic. The committee considered several items, including staff reports and updates on legislative changes to Chapter 1104 Texas Occupations Code and the Appraisal Subcommittee's proposed rule regarding collection of AMC National Registry fees. Committee also reviewed various action items and will renew its discussion of AMC audit practices and recommendations at a future meeting after any legislative changes to Chapter 1104 have been adopted in the session that's ongoing now with the legislature. We are losing one of our members, Mr. McNamara, informed the committee at the AMC Advisory Committee that he would not be able to serve anymore for being relocated to another state, and we'll certainly miss him. He's been long-term on the AMC, as I understand it, and a very fine contributor. We did not, at that time, schedule a future meeting date, but will in the future.
Perfect. Thank you, Mr. Jeffries. For the record, I believe they met on April the 17th and reported on that meeting today, May the 5th.
Sorry.
No worries. There was a question earlier. Your AMC committee is made up of, I believe, 5 people now? Is that right?
That is
Or-
correct. There are 5.
There were 5 spaces, and we've lost 2, as announced today. So Mr. Jeffries had asked earlier, and I asked the commissioner, what's the plan of attack on that committee?
Madam Chair and members, I spoke to the Governor's Appointments Office. I sent them, of course, notice, first of all, about Mr. McNamara's resignation, and then also Mr. Pistilli's question about whether he was eligible to continue when changing jobs. So I spoke to them, and then, so we've had a couple of conversations. The most recent one was just yesterday. And the governor's office, of course, is looking for replacements. But they also, because of the concern that we could have quorum issues, if there are 5 members we need 3 as a quorum, which means no one ever else could miss a meeting, right? Until we have more members. They were going to look and see whether it would be possible for Mr. Pistilli to continue until replaced, which is kind of the normal holdover, but because it's potentially a qualification issue, they needed to get some legal advice on that. So I expect to hear next week whether he'll be asked to continue until replaced, or whether we'll be dealing with just 3 members until we get new appointments.
Thank you for that report. Our next item on the agenda is item number 9, report by the Budget Committee. Mr. Black?
Thank you, Madam Chair. Well, you have before you the draft TALCB fiscal year 2018 operating budget, which Mr. Oldmixon is going to go into in much greater detail here shortly. But just to speak to it from the committee standpoint, the Budget Committee did meet last month on April 14th, 2017, and it was a teleconference initiated by Mr. Oldmixon. Those in attendance were Mr. Douglas Oldmixon, myself, Joyce Yanuzzi. And I would say the process went very smooth. We had a few questions, Joyce and I did, but everything was explained very well. I think it was well put together. And once again, Douglas is going to give a full report on, I believe it's agenda item number 21. And if y'all have any questions, ask away now, but I would direct any really good questions at that point if y'all have any, and let Douglas, Mr. Oldmixon, address those. Additionally, the Budget Committee met again this morning at 8:30. There was just a couple of minor changes which are reflected on what you have in front of you. Those in attendance were Mr. Oldmixon, myself, Clayton Black, Joyce Yanuzzi, Tony Pena, 3 members of staff as well, Aretha, Melissa, and Priscilla. And really that's all I have to report at the moment. I would like to add one thing. I want to thank staff. I think y'all did a fantastic job, so I'm real impressed with it. And whenever we had our initial teleconference, in about an hour going over it, so thank you, Mr. Oldmixon. I think you did a great job. Additionally, Aretha, Melissa, and Priscilla, thank you to the 3 of you as well. I think y'all did a fantastic job putting it together. That's my report.
Thank you, Mr. Black. Any questions of Mr. Black? Move to agenda item number 10, the report by the Education Committee.
Thank you, Madam Chair. The Education Committee did meet via teleconference on February 9th. Those in attendance from the committee were myself, Jim Jeffries, and Martha Gail Reed Lynch. We also had 6 members of the staff on the call, as well as 8 members of the public on the call. The primary discussion was the committee considered the development of new rules for approval of appraiser continuing education providers and courses and possible amendments to 22 TAC 153.18, which is the appraiser continuing education. The committee heard concerns from several FACT members and Ruth Kelton, who is Region 8 Director of AI, that the fees proposed under the new rules for education providers and continuing education courses are cost prohibited and would eliminate the ability of local AI chapters to host one-time CE programs for appraisers at chapter meetings. The committee tabled the discussion of this agenda item and asked staff to bring additional information and draft language regarding an exemption for one-time 2-hour course offerings for the committee's consideration at a future meeting. And then so that was tackled. We had a lengthy discussion on that. And then as well as that, the committee also considered the development of a 2-hour continuing education course for Texas appraisers in conjunction with the Texas A&M University Real Estate Center. The committee recommends the board establish a working group to work with staff and the A&M Real Estate Center to move forward with developing this course. The committee did not schedule a future meeting date, and I would thank, this was my first official meeting as chair of this committee, and I thank Kristen for holding my hand and walking me through the discussion. It's difficult over teleconference to know kind of where the questions come from and then just kind of maintain pace the way it probably should be held. So thank you so much for your help. It'll get better, I promise.
And Mr. Pena, we appreciate you stretching for us to serve in the capacities that we ask you to serve. It was reported that you did a fantastic job.
You did a fine job.
Just for the record, that meeting was held on April 19th.
Oh, pardon me, yes, I misread the documentation, April 19th. I did get the teleconference piece right.
Hey, we're working on a consistency factor, so the person making the enforcement report, stay the course, right? Go ahead and state the wrong date, and then we'll correct it.
Thank you, Madam Chair. I was making it a point to have the correct date reported, and the Enforcement Committee did meet via teleconference on Thursday, March 9th, 2017. All committee members who consist of myself as chair, Chance Bolton, and Alex Sostry were present. There were no other board members joining us on that teleconference. There were several staff in attendance. We appreciate their attendance and we appreciated their input. It's important to point out there were several members of the public in attendance, all those members of the public representing FACT, and included Joe Wohler, Mark Lowry, Amy Abels, and Greg Stevens. The committee considered several items, and they include a proposal to allow supervisory appraisers to supervise more than 3 appraiser trainees. We also considered recommendation for mentors and issues related to PIC members and mentor applications and assignments. We tabled the discussion regarding allowing supervisory appraisers to supervise more than 3 appraiser trainees, and we directed staff to gather additional information from existing license holders for consideration at the next committee meeting. The committee also recommended that the board allow mentors the discretion to allocate time spent on the mentorship topic specified in agreed orders, unless directed otherwise in the specific terms of such agreed orders. The committee also recommends that the board maintain deadlines set for PIC members and mentor applications and not consider any late or off-cycle applications. The committee recommended that the board direct staff to provide assistance to the PIC members as needed with regard to, for example, accessing MLS data to allow a PIC member to complete specific assignments that they have been designated with. The committee also had received a letter from FACT, the Foundation Appraiser Coalition of Texas, and directed the staff to set a date for a teleconference with FACT to gather information about the concerns raised in the letter for future consideration by the committee. And you will, I believe, receive a more detailed report on this teleconference that the staff held. At the time, we did not set a future meeting, and we since have not still set a future meeting date. But I'm assuming that one will be here in the near future. Thank you.
Thank you, Mr. Renfro, and thank you for your service and leadership on that committee. Next agenda item is number 12, the report by the Executive Committee. The executive committee is made up of myself as chair, Mr. Jeffries as vice chair, and Mr. Renfro as secretary. We did meet by teleconference on March the 27th, 2017, and all of your committee members were present. The staff in attendance included the commissioner, your general counsel, and Tony Slagle from Government Affairs. We appreciated Mr. Stevens with FACT also signing in to that teleconference and participating. We received updates from staff on a number of items, including proposed changes to the appraisal subcommittee policy statements, the appraisal fee survey, and posting a list of supervisory appraisers on the TALCB website. We also considered an appeal of staff's denial of an examination waiver of an applicant seeking to reinstate the appraiser license, and the committee recommended that the board affirm staff's denial of the examination waiver for this applicant because the license had been expired for more than 5 years. Additionally, the committee recommended that the board propose amendments to the TALCB Rule 153.16. That is your agenda item number 16 today. Committee also did not set a future meeting date, but anticipates one. Next item on our agenda is staff reports.
Madam Chair and members, my notes say good morning, but the clock says it's afternoon, so good afternoon and welcome to your regular quarterly meeting. Please recall that we are broadcasting live via our website, so be mindful of any side conversations. The microphones are sensitive. We are grateful for the time and energy that you give to the citizens of Texas to oversee the important work of the board. Thank you for being here to offer guidance and direction. It is May, and there are 24 days left in the legislative session, which ends on Memorial Day. And today, Tony Slagle will give you a progress report on the bills that we are tracking that could affect the agency and the public policies that we are required to enforce for the protection of the public. We continue to work with other stakeholders to attempt to ensure that there is no lessening of safeguards for consumers. The board's advisory groups, committees, and your staff have been working hard since you last met in February. You, of course, heard reports from many of them already today, along with some recommendations for action. We hope that the levels of discussion and deliberation that occur to reach these recommendations is sufficient to the task at hand. If it ever needs augmentation or you believe that there is a way to improve, please let us know how we might better serve you. You may recall that you authorized the completion of the third Texas appraisal fee survey in February. I'm pleased to report that this survey is now completed, and we will be announcing it very soon and publishing it on our website next week. You will all receive a copy of it as well, electronically, a link to it posted on our website. The reason we do this is to compile data to support one permissible source for AMCs to rely upon or for appraisers to use to assess whether the fees paid for appraisal assignments meet the federal definition of customary and reasonable. There's only a couple of rules recommended for adoption or proposed for publication on today's agenda. We expect this to increase somewhat, as it usually does after the legislative session and gubernatorial action. You also have a few items of administrative business to consider, including the appointment of investment officers, a report on our policy and process discussions with FACT, and the Commissioner's performance review. There are a few policy discussions on tap as well, including the exam waiver request policy, adding flexibility to topics and hours assigned for mentorship, the pick and mentor application process and access to MLS, and the process for writing a Texas-specific course for appraisers. And very importantly, you will consider the first draft of the fiscal year 18 agency operating budget as reviewed by the Budget Committee, and have the opportunity to ask questions about the underlying assumptions that went into its construction. I will be ready to answer any questions or concerns that you may have. The continued growth of license application volume, primarily on the real estate side, and educational offering approval requests, combined with a rise in complaints, primarily again on the real estate side, has required us to respond with additional resources to better manage the volume of contacts, calls, emails, and walk-in interactions that result from increases in each of these areas. So I wanted to let you know that I have approved adding staff in the Reception and Communication Services Division that handles calls, emails, and walk-ins, the Education and Licensing Services Division that handles the processing of applications, and also in the TREC enforcement area to respond to the need for timely action to serve our license holders as promptly and as professionally as we would want to be. In April, the Association of Appraiser Regulatory Officials held its spring meeting, and as usual, your staff was deeply involved in the federal and peer regulatory agenda discussions. I have asked our General Counsel, Kristen Warman, to give you an update report from that meeting. So unless you have any questions for me, I will now turn it over to Kristen, followed by each of the division directors to offer their quarterly update on activities in their areas of responsibility. Are there any questions for me? Thank you.
Good afternoon, Madam Chair and board members. Kristen Warman, your General Counsel. As the Commissioner mentioned, Troy Boyer and I attended the ARROW Conference, the Association of Appraiser Regulatory Officials. That is a conference of all state regulatory officials that is held annually in both the spring and in the fall. The spring conference was held in Tampa Bay, Florida on April 6th through 8th. And as a kickoff to that conference, we also attended the AQB, or Appraiser Qualifications Board meeting, and we listened to comments about the third exposure draft of proposed changes to the real property appraiser qualification criteria. Those proposed changes include changes to the college education requirements for a licensed residential credential, as well as providing an alternate path for a licensed residential appraiser to upgrade their credential to a certified residential credential without having a full college degree. But the AQB will maintain the college degree requirement for the certified residential credential. In addition, the AQB is proposing development of practical applications of real estate appraisal modules, or PAREA, as an alternative to obtaining experience through a supervisory appraiser. The third change that is being recommended by the AQB is reducing the number of experience hours required for each credential. The reduction would include 2,000 hours over a 12-month time frame to 1,000 hours with no minimum time frame for the licensed residential credential, a reduction from 2,500 hours over 24 months to 1,500 hours with no minimum time frame for the certified residential credential, and a reduction from 3,000 hours, including 1,500 non-residential hours over 30 months, to 2,000 hours, including 1,000 non-residential hours with no minimum time frame to the certified general credential. All those proposals are part of the third exposure draft, and the executive committee will be reviewing comments that we will submit to that third exposure draft next week. In addition, at the conference, I served on a panel that explored best practices for the regulatory supervision of appraisal management companies, and I gave a presentation on appraisal management company audits and best practices for those audits. That's a topic of discussion that our own appraisal management company advisory committee began discussing last year and had tabled until the federal rules related to AMCs were adopted. So I expect that that topic will begin being discussed at the committee level again and may work its way to the board for final approval at some point in the future. We also heard from federal and state regulatory officials on a variety of topics and issues facing the industry, including updates from the Appraisal Subcommittee, the Appraisal Foundation, as well as policy changes from Freddie Mac and Fannie Mae, granting experience credit for mass appraisers. Staff actually met with the Harris County Appraisal District following our attendance at this conference to help them understand how their appraiser employees can get a license from the board under Chapter 1103. So this was actually a timely discussion topic for us to hear. We also heard about developing the next generation of appraisers and the future of appraiser regulation. But noticeably missing from the conference was any sort of definitive update on congressional action regarding changes to Dodd-Frank. The commissioner and staff continue to monitor activities in Washington, D.C. regarding any congressional movement, and we will apprise you of any information that we learn. Thank you.
Thank you, Krista.
Good afternoon, Lori Deanda, Director of Reception and Communication Services. Before I begin with my staff reports, I have two new team members that I am introducing. Ana Sanchez began her employment with the agency as a customer service representative on March 20th. She has worked for the state of Texas in the customer service field for nearly 8 years. She studied in communications at the University of Texas in San Antonio. In her spare time, she enjoys dog sitting, reading, and crafting. Ana is thrilled in being part of TREC and TALCB. Please welcome Ms. Sanchez. Next is Michelle Resendez. She began her employment with the agency as a customer service representative on March 13th. She was born and raised in Austin. Michelle previously worked at Time Warner Cable for 14 years. She began her employment as a customer service representative and was promoted to a billing repair agent support specialist. She graduated with an associate's degree in bilingual business administration. She and her husband have been married for over 20 years and have 3 beautiful daughters. She is also excited to be part of our agency's team. So please help me welcome Ms. Resendez. So please refer to the C1 report. For the month of March 2017, we received 78,253 calls, assisted 389 walk-ins, and responded to 14,349 emails. Now you will notice the phone volume began escalating in the month of January. The normal call volume is an average of approximately 20,000 calls per month. The large number of calls is in regards to an automated dialing system that repeatedly dialed the TREC main number. We did have the call queue at the maximum level of 30 calls in queue. The 31st caller received a message that informed them to call back or send an email. This option also created the higher number of emails, which had us with a response time of approximately up to 5 business days. To resolve the problem, we have doubled the effort to reduce the email volume by hiring another team member. I am happy to inform you that we are currently responding to emails within a 2 business day time frame. The next report is a C2 report. The new website went into effect in February that also included an update on the surveys. March is the first month that I am able to view all surveys that include surveys without comments. In the month of March 2017, we received 121 surveys. On your report, there is a typographical error that has the TREC total as 110 surveys received instead of 111, so I do apologize for that. 111 surveys were submitted for TREC and 10 for TALCB. 49 surveys included comments and contact information. The top 3 comment categories involve the TREC website, hold time, email response, and the processing of documents. The email response time and processing of documents received an equal amount of comments. The 49 surveys with comments and contact information have all been resolved. The next report is the C3 report. So the numbers for the second quarter are for December 2016 through February 2017. The average length of time it took to complete a call was 19 minutes and 45 seconds, and the average hold time was 9.5 minutes. And this does conclude my report. Does anyone have any questions? Okay, thank you.
Good afternoon, Madam Chair, board members, and Commissioner. Gwen Jackson, Director of Education and Licensing Services. The first report before you for the ELS division provides the number of active certifications and licenses. At the end of March, there was an overall total of 6,096 active appraisers, which is an increase of 45 over that of March 2016. 23 of those 45 new appraisers are appraiser trainees, so we have new appraisers in training, obtaining experience, and working towards getting their licenses or certifications. The very last line item on this report reflects that we have approximately 1,319 temporary registrants and 153 appraisers who hold inactive certifications or licenses. The next report in your material is for Appraisal Management Company, or AMC, registrations. To summarize, there were no new AMCs registered during the month of March. Since the AMC program began in 2012, 19 companies have surrendered their registrations, 3 were revoked, and 43 registrations are expired more than 6 months. This brings our March total to 172 AMC registrations. The next report in your material is the L1 report. This report provides March fiscal year comparisons for applications received, licenses issued, and renewals. Our fiscal year comparisons are negligible for this period, as we see a slight increase of about 4.5% in applications received, from 500 in March 2016 to 522 this March, and an increase of 44, or almost 2.5%, in renewal licenses issued. Following this report is our examination activity report. A total of 116 examinations have been administered. Examination pass rates for the licensed residential appraiser is at 50%. Certified residential is at 64.5%, certified general at 74%, and our overall pass rate for appraisers is 61%. The bottom portion of this report provides examination activity results only for the month of March. And then the last report is our year-to-date examination comparison through the month of March. To summarize, we have healthy increases in pass rates for both certified general and certified residential appraisers, and a slight decrease from 52 to 50% for the licensed residential appraiser. Our overall appraiser pass rates has improved by almost 9% over March of last year, as the overall pass rate increased from 52 to 61%. Unless there are any questions, that concludes my report. Thank you.
Good afternoon. I am Tom Watson, Deputy Director of Information and Technology Services. If you refer to the I-1 report, in the middle of the report, it is representing the online transactions for initial applications. And we are continuing to see slow and steady improvement and utilization or increases in utilization of those particular online services. The latter half of the report shows the renewals, and those are continuing to be extremely strong at about 90% utilization of online services to do a renewal. And those numbers are extremely steady and consistent over the past months and years. On the next page, on the I2 report, is actually a visualization of those same statistics. On the top is the initial applications. You do see a slightly upward slope in the line showing continued improvement in those utilization numbers. In the middle of the page is the renewal numbers, showing that it's pretty steady from month to month on license holders coming to the online services and using those tools. So we're happy to see the strong numbers on the renewal side and look for the continued improvement on the initial application side.
Can I ask you a couple of questions?
Sir.
So I am happy to see the strong numbers as well, and I think it's imperative that we tell you what we're hearing on the ground. I'm not sure if we had a level of frustration monitor, if it wouldn't be up. So we're getting some feedback from appraisers who are trying to make application online, and it may be a learning curve, that they're having difficulty. So is there a way when they're in the midst of trying to either make application or renewal, and they're having trouble, is there some way that you all are aware of that? Like, are there places they're leaving comments? Are they coming in incomplete and having to be handled back and forth a time or two?
Typically, the most comments that we get as a division come from Lori through the communication group. Okay. They are the first line of typical communication towards the license holders or the applicants. And we do hear some of the complaints and continually work on her top items. So, she gets a general feel for this particular item appears to be higher than normal, higher than typical, out of range. So we work pretty closely with her to identify what might be causing those situations.
Okay.
And I will say that, we continually are addressing the issues, and we have some pending issues that we are currently working with her on.
Can you describe what those might be? Are they processing issues or?
Well, at the moment, generally, it's the ability to sign in through either not remembering, not knowing, or password and user ID type of issues. And it could be a combination that either one, they don't remember, or two, the website is not properly handling those credentials. We are currently looking at the possibility of the website not interpreting the password correctly, and seeing if there might be something there causing some higher volume of calls.
But it's because it's incredibly unusual for me to hear anything on the ground, and I've heard from a few other board members that they've had similar conversations with folks on the ground. So that's the reason I wanted to bring it to your attention. Lori, maybe that's why your calls are up, right?
I have not heard anything specific beyond that point in terms of the process to complete the application, but I can certainly reach out to the various divisions to see if they are noticing trends.
I think we can probably report to you what we're hearing, and that may help you. If there are other board members that have had that experience or had someone share any specificity with you that might help the staff, I think that would be good.
Yes, I got something. It seems like I've got an email regarding this and maybe even a letter in the mail, but it was I'm trying to recall specifics. It was basically just response time was pretty slow, best I can recall. Let me see if I can find the letter, but y'all continue.
We have actually addressed some performance and response time issues, both from an internal response time look as well as a external or website look. We put some things in place about a month ago to help improve that situation.
So I've had multiple, I guess I've attended too many appraiser conferences, but and they all know I'm on the board. But one specific item that I've heard multiple times is that, and maybe I'm incorrect, and I personally experienced this myself in my renewal, is that once you get through the process, it's my understanding you're supposed to receive a receipt of the transaction. And I've had multiple people come to me and say that they are not getting that receipt. In my particular case, the email that was supposed to be the receipt was actually a 30-day license. It issued me a renewal, but it was only good for the rest for 30 days, which really confused me. I thought maybe you guys knew something I didn't, but.
We got to watch on you.
Well, I did, but I did get other people come to me and say they were having trouble just getting a receipt, in addition to the response. And I think off that was trying to call in and not even being able to get on hold in the phone system. And I understand that you're addressing that, but that was a specific issue that's been pointed out to me.
Okay, thank you. You should actually get a receipt, and I believe a copy of the application itself, so, and that's prior to the license showing up, so, thank you.
We just got to watch on you, Buster. We're going to issue yours every 30 days. Mr. Jeffries, did you have some?
I would echo what Buster said, that and it may be the case that a lot of us older appraisers are going through the reissuing of our certifications in a cluster. That may be the case, that one of the reasons why there's such a volume. But I had quite a lot of difficulty working with the website to get my certification, and the end result was that I thought I'd sent everything in and didn't hear anything, and then all of a sudden one day my recertification certificate came in a different email. So I think the interaction between the website and the person that's trying to work with the website is not really all that good at this time. You don't really get any accurate feedback on what is necessary to complete the application, and then it's somewhat cumbersome on how to submit your continuing education evidence. So I had that experience. Luckily, through perseverance and about 3 days of messing around with it, I finally got my recertification.
Thank you.
So good feedback. That'll always giving us opportunities to improve. And I'll join Mr. Jeffries. Maybe we're renewing the older folks in a cluster and we're not accustomed to the process, right? So it's different than what we're used to. Some of that probably does complicate the matter.
I'd like to make the comment that I don't want everything to be negative, but even though I thought everything got through and went in, even though I didn't have that verification, I will have to say this. I did get my renewal license in 7 days, which I thought was quite timely. But during that period, I was still a little unsure whether it actually went through okay because of that erroneous 30-day license that I got issued. And I took it upstairs because I have the unique advantage of working in this building. And the staff there promptly helped me too. They printed, I think, an on-screen printout of my receipt. But I did get it back in 7 days, which, I mean, I was pleasant. I thought that was a quick turnaround when you consider that you have to turn in your education and all that. So once I got that real license, I kind of relaxed a little bit and felt like everything was back in order. It kept me from having to call Jamie and figure out what was going on. Thank you.
Thank you. I'll be happy to answer any other questions you may have. Thank you for the observations. Appreciate it.
Thank you.
So, good afternoon. I'm Priscilla Pifo, Director of Staff and Support Services, and I'll be presenting your operating budget update and investment report. The TALCB operating budget status report, you'll notice that there's expected 7 months through the fiscal year so far, which means we have 5 months worth of expenditures, or about 42% of budget is our target. Looking at the expenditures, 44.9% remaining in the budget to be spent, which means we've spent a little bit less than our target. Under revenue, you can see that we continue to trend slightly upward. At our last meeting, we reported we were up about 1.5%, and at this meeting, we're up about 3.7% ahead of projection on revenues. Moving on to investments. For Operating Fund 3056, which shows, again, the laddered approach to investments coming due quarterly throughout the year to allow for maximum liquidity. Our investment balance, or ending market value, is $646,638 and some change. I'd be happy to answer any questions. Thank you very much.
Thank you.
Good afternoon, Madam Chair, board members. Troy Bollier, Director of Standards and Enforcement Services. Before I go through my reports, I wanted to introduce a new staff member, Sherry Gonzalez. Sherry started with the agency in April as our new legal secretary. Sherry comes from East Texas, and she has a bachelor's degree in criminal justice and a master's degree in psychology. And in her spare time, she enjoys gardening. So we're very happy to have Sherry on our team and like to welcome her to the agency. So if you take a look at the E1 report, and of course, the first thing you can see here is this is case activity through March 31st of this year. And if you look at the bottom left-hand corner, the total number of cases that are currently open as of the end of March is 229. The top half of the report concerns matters that we have received. And if you look over on the far right-hand side, in the brown line there, there's 202 total matters that we've received. And the bottom half of the report concerns matters that have been closed. And you can see the information there. And in the bottom right-hand corner, the brown line, we have 175 that we have closed so far. So currently we're on track, looking at the total number of complaints we've received, to probably hit around the 200 mark, like we did almost last year.
Troy, before you leave that page, it looks like there's a doubling of complaints opened in the month of March. Was there any unusual?
Yes, ma'am. Thank you for mentioning that. There was an unusual spike in March of complaints related to some unlicensed activity that was just a unique circumstance. So,
thank you.
The second report you have is for appraisal management companies. And you can see at the bottom left-hand corner of the page that we have 11 pending appraisal management company complaint matters. Not a whole lot of activity. The report is structured the same, so the top half shows you complaints that are incoming. We had one in March. So far this year, we've had a total of 5 complaints received. And then you can see in the bottom half of the chart, number of cases closed. We had 1 closed in March, and a total of 5 closed this year, so not much activity on the appraisal management company side. The next report you have concerns total open complaints related to appraiser matters, and you can see by year the activities. Of course, we do have a few straggling cases in 2009 and 14, and some in 15. Of course, those are all what we call requests for assistance. Those are those law enforcement assistance requests as part of the mortgage fraud task force that we're asked to provide appraisal expertise in. All of those matters are still pending, and we of course regularly stay in contact with our law enforcement partners so that as soon as they are finished with their work, we can close out those matters. I can tell you the oldest two, the 2009 case and the 2014, are pending in federal court on a criminal matter. I will mention that the 2015 matters there, the 8 requests for assistance, 7 of those we actually got word from our law enforcement partner in early April, just shortly after this report, that they could be closed. So when you see the report next meeting, there will only be 1 there. And then you can see we're obviously making progress working on the 2016 and 2017 matters. And slowly bringing those to resolution. The next slide that you have concerns complaint resolutions for the current fiscal year through March 31st of 2017. And you can see from the pie chart on the left-hand side that we have 94 total complaints resolved. The majority of those, as you can see, are some form of a dismissal. It's roughly about 74% of the cases we've received so far. And then we have 24 matters that have been resolved in some agreed fashion, either an agreed final order or a voluntary surrender. Currently, although we do have some things pending, there's no cases yet as of this report that have been litigated, and we haven't had any default cases that are resolved by default. And then the bottom on the right-hand side, you can see the recidivism rate for FY 2017, which is down quite a bit, 12.5% from last year. We'll see how that continues as the year goes on, obviously. Things may change. And then on the left-hand side, the chart there gives you a little bit of a historic perspective on the percentage of license holders with disciplinary action. And so far for FY 2017, that's 0.2%. And you can see underneath there the total number of license holders that we use to make that calculation. The next slide gives you an idea of total number of complaints received based on the different licensure categories. And so you can see the historic trend all the way back to 2010 and where we are currently in FY 2017. And then finally, the last slide gives you information about staff-initiated complaints based on experience audits. And on the left-hand side, you can see the historic trends by different categories, you know, whether it was a trainee, someone who was upgrading from, say, a license to a certification, if it was a supervisory appraiser, or if the audit generated a complaint to an AMC. And you can see for FY 2017, so far, we have 3 that were initiated against supervisory appraisers. And then, of course, on the right-hand side, you can see all of those complaints aggregated into a pie chart and kind of get a breakdown of what those percentages are. So that concludes my regular report, and I'd be happy to answer any questions about that. And if not, I have one additional supplemental report to share with you. And the report you have in front of you here, you may have received notice about by email, and it's also on our website. There was recently a publication issued in Appraisal Buzz regarding the complaint process in general nationwide. And in that article, some reference was made to some Texas-specific statistics about the likelihood of a residential appraiser receiving a complaint in a particularly busy year as being 1 in 6. And so the staff took some time and looked into what the historic information was about complaint rates and complaint volume, and that information has been provided to you here. And you can see in the busiest of years, which was FY 2010, there were 364 complaints received that year. That for residential appraisers, the odds were actually 1 in 13. So we wanted to share this information and make it available for license holders and the public so they can better understand what the information really shows about the likelihood of receiving a complaint. So I'm happy to address any questions that you may have.
Thank you, Troy.
Thank you.
Good afternoon, Madam Chair, board members, Tony Slagle, Government Affairs. I'm going to give a brief report on an update on appraiser demographics. For the new board members, just so you know, we started tracking this about 4 years ago. And every May, I provide an update to everybody on where the trends are. If you look at the first page, which is Texas-specific numbers, you'll notice that we're first of all, want to apologize on the gender. It says Series 1, Series 2, blue is male, red is female, just so you have some clarification on that. I apologize for that mistake. But if you notice on the, in terms of statistically for ethnicity and gender, in terms of the population, appraiser population, not much has changed since the peak year of 2007. It's maintained pretty flat numbers statistically in terms of the makeup of the ethnic makeup and the gender makeup of the appraiser population over that time period. However, on the age of the appraisers, we've been trending in Texas. We've been trending older. In fact, if you look at the appraiser numbers on that graph, 50 and below have dropped, and 50 and above have trended upward over that period. So while we've maintained this relatively the same levels statistically for ethnicity and gender, for age, we are, as a population, the appraiser population in Texas is getting older. If you look at the next page, which is a comparison of Texas versus the national numbers, we take these numbers from the evaluation report done by the Appraisal Institute. The most recent one was done for 2016. It's a survey conducted of 2,000 appraisers, roughly 2,000 appraisers nationwide. If you look at those numbers, we are slightly less diverse than the national numbers, although we do have more Hispanic appraisers than the national numbers indicate. If you look at the next page, which is gender, we're slightly more male than the national numbers. And then although we are trending older in Texas, we are slightly younger than the national numbers. The age 50 and older, lower, younger, makes up 44% of the numbers in Texas versus 38% of the national numbers. And I'm happy to answer any questions if you have any. All right, thank you.
Madam Chair and board members, are you ready for the next agenda item?
We certainly are.
Thank you. Kristen Warman, General Counsel. As the chair of the Enforcement Committee alluded to earlier, I'm here to report to you on the teleconference that staff held with FACT. The Foundation Appraisers Coalition of Texas, or FACT, had sent a letter to the board expressing some concerns about the enforcement activities of the board. And the letter was referred to the Enforcement Committee, who directed staff to hold a teleconference with FACT to address the concerns raised in the letter. The 4 areas of concern that FACT included in their letter was feedback that they were receiving from mentors who had mentored an appraiser as part of the terms of an agreed order or contingent dismissal resolving a disciplinary complaint. Excessive delays in processing applications, issues with investigator phone calls and requests by appraisers to respond to questions in writing as opposed to over the phone, and complaints against supervisory appraisers. The teleconference was held on April 3rd to address these concerns, and FACT discussed comments to explain each area of concern that was raised in the letter. Staff responded by sharing information that was gathered after researching each area of concern that FACT had expressed. Staff explained the application process for an appraiser license, which requires the board to verify that each applicant's experience meets the requirements established by the Appraiser Qualifications Board and complies with USPAP. Staff also shared the information and statistics included in your materials at pages 98 through 100 and pages 104 through 106. Turning to page 98 of the materials, staff was able to discern that from the time period of September 2014 through February of 2017, there were 369 experience audits that occurred when an appraiser is either upgrading their license or seeking a license for the first time. Of those 369 audits, 349 were closed, and of those 341 closed audits, 306 were approved and given a license, 24 were denied, and 11 were withdrawn. On page 99, staff researched the average number of days to process an application for a license, and what we found was that in fiscal year 15, the average number of days was 89. This dropped to just over 82 in fiscal year 16 and continues to trend downward in fiscal year 17. To date, the average time to process an application is just over 54 days. This includes the time that runs after staff requests information from the applicant. So it includes the time that the applicant then responds to staff with that information for us to continue the license experience audit. In addition, on page 100, you can see the staff-initiated complaints based on experience audits, which our enforcement director just went over with you. This chart only covers 3 years, the last 3 years, and shows that over this 3-year time period, we had 10 total complaints. 9 were initiated against a supervisory appraiser, and 1 was initiated against an AMC. And of those 10 complaints, 3 are still open, 4 were contingent dismissals, 2 were agreed final orders, and 1 was dismissed with a warning. There were no complaints against trainees during this time frame. And this represents only 2.6% of the audits, or 9 out of the 341 audits closed during this time frame that resulted in a complaint against the supervisory appraiser. FACT agreed that the information and statistics shared by staff were helpful, and in addition to sharing this information, staff agreed to take the following actions to help improve communications and feedback during the mentoring process and improve the overall mentorship experience. Staff will develop and implement evaluation forms for both mentors and respondents to solicit feedback about the mentorship experience so that staff can continue to look for ways to improve that experience. As part of the PIC member and mentor training that was held on April 24th, staff has already rolled out those forms for the mentors to use and is currently sending those forms once the mentorship has been completed to both the person receiving the mentorship and the mentor who is providing the mentorship. In addition, staff will develop a summary referral form to provide mentors who accept a mentorship assignment that will provide the mentor with more information about the USPAP compliance issues identified by staff during the investigation or the experience audit. Essentially, what was happening was when an agreed order was entered into and a respondent was asked to complete mentorship, our process left it to the respondent to make the arrangements with the mentor and complete that required mentorship. The only thing that staff got back from the mentor was a completion certificate once the mentorship had been completed. Now, some of the mentors would contact staff and ask for more information, but we found that that was typically lacking. So there was no communication between staff and what we were finding in the investigation and what the communication the mentor was receiving from the respondent when the mentorship was occurring. So the development of the summary referral form is designed to help improve that communication so that it will allow the mentors to ask questions of staff about why it is we were referring this individual to mentorship. FACT expressed their appreciation of staff's time and the open dialogue shared during the teleconference. Staff appreciates the opportunity to address the concerns raised by FACT, and staff is committed to continuing the open dialogue and the exchange of information and collaboration between the board and FACT. Do you have any questions?
Just a quick comment. Thank you for the work, and thank you, FACT, for actually calling the concerns to attention so that the conversation could occur. I do think it's always important for us to remember that while we are the regulatory agency and it's our responsibility to regulate, equally, and maybe more importantly, it's our responsibility to educate. And as we continue to clarify that, I think it's a positive direction and good input. So thanks for the hard work. There was lots of heavy lifting on the part of our staff to get information back out to the industry and to the FACT representatives, and equally, maybe not equally, but heavy lifting as well on FACT's part that was expressed, certainly at least to me and I believe other appraiser members, that wasn't an easy letter to write. That wasn't something they particularly, there was lots of maybe wringing of hands before one was released to us. So it takes bravery sometimes to make improvement, and we appreciate you doing that. Anything else? Any other comments? Very good. Guess, Kristen, are you going to handle the adoption of 153.5?
Yes, Madam Chair.
Would you like to move to that, please?
Sure. Agenda item 15 is the discussion and possible action to adopt amendments to 22 TAC 153.5 fees. The amendments change the reference in this rule from the fee for an evaluation of an applicant's criminal history to the fee for an evaluation of an applicant's moral character to align the rule with the statutory requirements in Chapter 1103, Texas Occupations Code, and current board practice. No comments were received on the amendments as proposed, and staff recommends adopting the amendments as published.
Are there any questions?
Madam Chair,
Mr. Jeffries.
I move that staff is authorized on behalf of this board to submit for adoption amendments 153.5 fees without changes to text as published in the Texas Register, along with any technical or non-substantive changes as required for adoption.
Second.
A motion by Mr. Jeffries, a second by Mr. Bolton. Are there any questions? All in favor?
Aye.
Any opposed? Motion passes unanimously. We are to agenda item number 16.
Agenda item number 16 is the discussion and possible action to propose amendments to 22 TAC 153.16, license reinstatement. The proposed amendments clarify requirements for applicants who apply for license reinstatement and explain when an applicant for license reinstatement is eligible for an examination waiver. The Executive Committee recommends the board propose the amendments as presented. Staff also recommends proposing the amendments as presented.
Madam Chair.
Yes, I'm not sure where that voice came from, but go ahead.
Way over here.
There you go, Mr. Pena.
Yes, I move that staff is authorized on behalf of this board to submit amendments to 22 TAC 153.16, license reinstatement, as presented for publication and public comment to the Texas Register, along with any technical or non-substantive changes as required for proposal.
Second.
A motion by Mr. Pena. We're going to give Joyce the second. Mr. Black, I think you guys tied in terms of your, your statements. So we have a motion and a second. Any discussion? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. We'll move to agenda item number 17, the update on the long-term facilities plan from our commissioner.
Madam Chair and members, on behalf of the agency, I continue to have regular meetings with the Facilities Commission, as well as other parts of government. We received a notice from the Facilities Commission that essentially they are focused heavily, of course, on phases 1 and 2 of the current capital complex master plan. So the master plan was adopted last legislative session, and phase 1 was funded last session, and that provides for the construction of 2 buildings in the capital complex. One will be directly across in the very large parking lot across from the Bob Bullock History Museum next door. That entire area. In fact, they've already started some of the subsurface explorations so that excavation can begin on that. And then there will be another building which will be on the same side of Congress in the parking lot. So that's the parking lot north of the Travis building. There'll be one in the parking lot south of the Travis building. That will also include subsurface excavations down to 5 levels below grade for underground parking as part of those buildings, and Congress Avenue, the street itself, will have parking underneath it, and it will be converted to a bus lane only, but primarily a large promenade that goes from the campus all the way to the Capitol. I encourage you to go to tfc.state.tx.us, TFC for Texas Facilities Commission website, and I can also forward you a link to it for description of all of that planning. They will actually do a ceremonial groundbreaking later this month on that project, and then the actual groundbreaking will take place in June. But while the legislature is in town during May, they want to get everybody together and do a ceremonial groundbreaking there. It is it's an enormous legacy creating project. It's just a master stroke of long-range planning. Phase 2 is actually proposed this year for funding at the legislature, and that will include 2 more buildings, and then phase 3 has 2 more buildings. All of that combined will create, I want to say, in the neighborhood of 3 million square feet of office space in the Capitol complex. None of that includes Lot 19. Lot 19 is what's called an opportunity tract. So those 6 buildings is the primary focus of the master plan, but the plan also sets out criteria for the development of other parcels sets out the guidelines for the development of those parcels within the Capitol complex. Lot 19 is one such plan, or one such parcel. We have a preliminary agreement from the Facilities Commission to lease that parcel to us for construction of a building. We have a massing study from the Facilities Commission which shows the size, placement, and approximate cost for a four-level building, 2 levels of parking, all above grade. nothing excavated below, that drives up the cost significantly to do that. But 4 levels above grade, which still leaves us below the maximum height for this parcel, is directly in the Capitol View corridor. And in fact, it is a direct line of sight between the tower and the Capitol Dome. So we would be right there in the catbird seat. But 4 stories is the maximum we can do. So 2 levels of parking and 2 levels of office, comprising about 55,200 square feet of projected office space, which is about twice what we need. And so I have explored inviting partners, other SDSI agencies who do not currently have buildings, to partner with us to come in as joint venture partners, in essence, for the development of that building. Both of those, the chairs of those committees and the executive directors, the chairs of those commissions and the executive directors of those agencies have met with me and have given us preliminary positive. They would like to continue the discussion because they see potential there. The project in total, with construction beginning in 2019, late 2019, is anticipated to cost somewhere between $25 and $27 million. So the financing of the project now becomes the major issue. Previously, with 1 level of parking and 1 level of office, which is all we needed and was the original plan with the Facilities Commission, direction from the Facilities Commission, but considered and adopted, or we were on that path prior to the adoption of the master plan. The master plan requires each and every parcel in the Capitol complex to be developed to its maximum economic potential, which calls now for the doubling, essentially, of the size of the building, requiring us to find other partners as well as other sources of financing. We do believe that we are on track to have more than half of the required funds available by the time construction would begin, and so we are exploring where the additional monies would come from. One of those possibilities is to have the legislature authorize the deferral of our current agency's contribution to the general revenue of $750,000 per year for a period of 10 years, so $7.5 million, to not be paid into GR, but to be paid to repay debt. If we would borrow $7.5 million to close that gap on available funds versus total construction costs. Language to that effect is currently in the House version of a bill that has been reported favorably from committee. It was substituted, it has that language in there. The Senate version of the bill that had original authorizing language, we now have new authorizing language, which includes the specific identification of that parcel, specific authority for the Facilities Commission to enter into a lease with us, long-term lease with us, and specific authority for us to construct a building on that location. All of that language is in a current House version of an amendment to Chapter 1105, which is our SDSI Act. Are there any questions?
I have one quick one.
Certainly.
Previously, the board had an active board member working alongside, I believe, a quasi-subcommittees on the building project. Do we have anyone in that capacity right now? I believe our board representative
Was
was
Mr.
replaced.
Padden.
Yes.
Yeah, it was Mr. Padden. And I don't know that we have appointed another person to act in his capacity.
I don't believe we have, so I'll put that on the list of things maybe we want to think about at some point.
Wonderful. And if anyone, certainly, part of that working group was simply interagency between TREC and the board, to have some go-to folks for me to kind of bounce things off of, because this is a long-term, lots and lots of moving parts kind of a plan, and highly speculative in terms of, it's kind of a chicken and egg. We did get one of the reasons why the language was removed from the Senate version was that the sponsor of the bill sits on the Capital Complex Master Plan Review Committee, and he'd never heard of the project. Well, it's like, I need authorization to do the project before, and of course, the Facilities Commission is the partner. They're the ones who control the site. But in any case, they had not brought it to his attention because it was too early in the process. So we've remedied all that and have visited with others in leadership about it. So we feel fairly good about the potential for getting the authorization language through. The funding language is still up in the air, and we'll see if that goes through or not. We have other potential options if that one funding mechanism that we've suggested does not happen. We are exploring with the Facilities Commission and the state financing. What is the name of that agency? I apologize. There's a state, I don't know, finance, it's not the Finance Commission, that's a different issue, sorry. There is a state agency that's responsible for issuing bonds and borrowing, setting up loans and all that kind of stuff. What's it called?
The Texas Public Finance Authority.
Perfect. The Texas Public Finance Commission, I think, is actually authority. Okay. Any other questions?
I'm curious, I don't know
Yes.
if you can divulge this, but what are the other agencies that might come in on a joint venture?
The two that were invited and have considered it tentatively and positively are the Board of Accountants, as well as the architects. It's actually
Commissioner,
called the architectural examiners. I'm sorry.
Would they be tenants or actual partners?
Both options are available. I've invited them to be partners, but they could be tenants as well.
One other question.
Yes.
What's the rent on the land?
That is to be negotiated, but it will be extremely modest for a long-term period because we are state agencies. And the development of that land, if we don't do it, it's such a problematic site that it is likely it would wait at least another decade before it was ever considered what would be constructed there, because it's long-term getting these other large buildings, and there are much other larger parcels that are opportunity parcels. This is a very small parcel, and so it's kind of the lowest priority. It has the most problems, which of course for us makes it the most opportune.
Thank you, Commissioner.
Okay.
Agenda item number 18, update on legislative matters. I haven't fed this board, so I'm passing wintergreen lifesavers around if you'd like some. We've got a few left if the audience needs
I promise to make this very short. So, Tony Slagle, Government Affairs. I passed out a report that everyone has. My thought process is I'll focus on a couple of bills that have impact. You guys can ask me any questions via email, or if you have any obviously at the end of this, but once you've had a chance to digest it, if you have any questions about anything, I'm more than happy to answer them. I'll also email this to everybody after the board meeting. So I did want to focus on the changes to Chapter 1104, which is the AMC Act. There are two companion bills going through the legislature right now, the House bill and the Senate bill. The Senate bill was passed out of the Senate with, as it was filed. We noticed there were some drafting errors in that version of the bill that the Texas Legislative Council had, inadvertently made, that we asked to be corrected on the House version, and that the House version has been voted out. At some point, they will overlap. I believe the Senate bill is the one they're thinking will be the vehicle for the changes in the act. So at some point, they'll catch up with each other, and the Senate bill will make those conforming changes to what the House bill did, and it'll hopefully go through and pass without any issues. They're non-substantive for the most part, but they are necessary in terms of clarity. The second bill I wanted to focus on were the changes to Chapter 1105, which is our SDSI Act. Those changes are part of a large change to various acts that affect several SDSI agencies, primarily to standardize the reporting requirements for those agencies, as well as the bill sets up a process by which new agencies can ask for and receive SDSI status, and also a review of those that currently have it, and any recommendations to change that status in the future. So that bill has currently been voted out of the Senate. It is a Senate bill. It does not have a companion in the House, but it has been referred to a House committee and is awaiting a hearing on the House side. The next set of bills I'd like to focus on are on page 3. I apologize, the report's not numbered, but on page 3, HB 1712 and SB 526. Both of those deal with the residential mortgage fraud task force, of which this agency as well as the commission are a part of. Those bills would repeal that task force, but in the process we have been in contact with the authors to ask them to include language in the statute that would still allow us to share information with the current members of that task force, so that we can continue on with the mission of dealing with mortgage fraud, and they both agreed to do that. So hopefully if one of these bills pass that do repeal that task force, then that language will be in there so that we can continue to share that information without any issues. Okay. The next set, I'm going back, I apologize, I skipped over. There's two bills dealing with, related to tax appraisers on for the CADs. One is HB 2043 by Springer, and the other one is SB 521 by Creighton. There's similar bills in that they would require, the first one, the House bill, would require the court to give preference to an employee of an appraisal district testifying regarding the value of real property in a judicial appeal. Last session that happened. What this bill does is it proposes changes that would require an employee of the appraisal district to be licensed by the board if they're testifying to the value of real property that is appraised at $1 million or more, and to give preference if it's a property that's appraised at less than $1 million to someone who is licensed by the board. On the Senate side, that bill, as I said, it's similar, but it requires, it doesn't make a distinction, and it just requires that the person be licensed by the board if they're testifying before a judicial appeal on those issues. And then the last set of bills I would like to draw to your attention are, are just what the commissioner already spoke about, which are HB 2534. They're on the second to the last page, and SB 212. Those are the bills that amend Chapter 1101, but they also have language dealing with the construction of a building. And you can see on there where they are in the process. The commissioner already explained what the differences are and where those are in the process. But that concludes anything, unless anyone has any questions about what they saw looking at this in the first place. Again, I know it's a lot to throw at you at the end of the day. I apologize, but I am happy to answer any questions via any email that you have or And you know?
Anyone have specific questions of Tony? Tony, thanks for always doing a good job for us.
Thank you.
Next item on our agenda is agenda item number 19, the discussion and possible action regarding the appointment of an agency or of agency investment officers.
Madam Chair and board members, as shown at page 118 of your materials, Section 2256.005F of the Texas Government Code requires each agency that invests funds to designate one or more officers or employees of the agency to act as investment officers and be responsible for the investment of its funds, consistent with the policy adopted by the agency. Staff recommends the board designate investment officers by position rather than by named individual. The Director of Staff and Support Services and the Chief Accountant are the two positions that should be designated as the agency's investment officers.
Any questions?
Madam Chair,
Yes.
no question, but I'd like to form a motion.
Mr. Black.
I move that the board appoints the Director of Staff and Support Services and Chief Accountant to serve as the board's investment officers.
Second.
A motion by Mr. Black, a second by Mr. Bolton. Any discussion? All in favor?
Aye.
Aye.
Anyone opposed? Motion passes unanimously. We will move to agenda item number 20, discussion and possible action regarding committee recommendations. Number 1 is the Executive Committee recommendation regarding an examination waiver. And item B is the Enforcement Committee recommendation regarding the allocation of mentorship time under the terms of a board order. C, the Enforcement Committee's recommendation regarding the consideration of PIC member and mentor applications. D, the Enforcement Committee's recommendation regarding access to MLS for PIC members. And E, Education Committee's recommendation regarding creating a working group to draft a 2-hour continuing education course for Texas appraisers.
Madam Chair and board members, the agenda item under 20A regarding the examination waiver, the board previously adopted earlier at this meeting, the board previously adopted TALCB 15316 license reinstatement that allows an individual to apply to reinstate an expired appraiser license. That rule currently allows the board to waive certain requirements, including the examination. Mr. Richard Cole applied to reinstate his appraiser license that had been expired, and staff denied Mr. Cole's request for an examination waiver because his license has been expired for more than 5 years. At the last meeting, Mr. Cole requested the board to reconsider staff's denial of the examination waiver, and the board referred this request to the Executive Committee to bring back a recommendation to the board. After due consideration, the Executive Committee is recommending the board affirm staff's denial of an examination waiver.
Do you have any questions? Generally, I'll give you a background that the Executive Committee asked staff what the normal practice had been, what the parameters that we had been used previously, what the basis for the original staff denial was. We were given the 5-year window of time. The Executive Committee asked for confirmation from staff that had never, that we'd always utilized that as a criteria. Staff did go back and check that, reported back to the committee that in fact that had been a hard, fast rule, if you will, and therefore the Executive Committee recommendation comes forth to you as you requested us to take it up.
Madam Chair, I would like to move that the board adopt the Executive Committee's recommendation as presented.
We have a motion by Mr. Soster.
Second.
A second, was that you, Mr. Pena?
Yes, ma'am.
I apologize that I can't see you when you're acting. We have a motion and a second. Any discussion? All in favor?
Aye.
Anyone opposed? The motion passes unanimously. 20B.
Madam Chair and board members, Agenda Item 20B, discussion and possible action regarding Enforcement Committee recommendation regarding allocation of mentorship time under the terms of a board order. The board held a mentor roundtable in November of 2016 to ask and receive feedback from board-appointed mentors. One of the recommendations made by the mentors at the roundtable was for the board to specify a total number of required mentorship hours and the topics to be covered within that period in an agreed order, and allow the mentors to decide how to allocate the time spent on those specified topics. The Enforcement Committee considered this recommendation from the mentors, and the recommendation from the Enforcement Committee is to allow the mentors discretion to allocate time spent on the mentorship topics specified in an agreed order unless directed otherwise in the specific terms of the order. The Enforcement Committee recommends amending the policy memorandum regarding board order guidelines to reflect this change. The amendments to this policy memorandum are found at pages 123 through 126 of your materials. You can see the red line and the clean version.
Does the board have any questions?
Madam Chairman,
Mr. Bolton?
I move that the board adopt the Enforcement Committee's recommendation as presented.
Second.
Motion by Mr. Bolton, a second by Ms. Lynch. Any questions? All in favor?
Aye.
Anyone opposed? Motion passes unanimously.
Madam Chair and board members, Agenda Item 20C, discussion and possible action regarding the Enforcement Committee recommendation regarding consideration of PIC member and mentor applications. The board appoints PIC members in even-numbered years and mentors in odd-numbered years for 2-year terms. Each year, the board requests applications and accepts submissions until the application deadline set before the board's quarterly meeting in February. In past years, the board has considered late applications or applications filed after the deadline at the board's next meeting in May, but the board has never considered off-cycle applications or PIC member applications submitted the year mentors are appointed and vice versa. After the board appoints PIC members or mentors, staff conducts in-house training to inform PIC members and mentors on current requirements and provide updates and changes in the law or board rules and processes. Both late applications and off-cycle applications create additional work and may require staff to hold duplicative training courses to get late or off-cycle applicants up to speed. The Enforcement Committee recommends that the board maintain the deadline set to receive PIC member or mentor applications and not accept late or off-cycle applications for PIC members or mentors.
I have a quick question of somebody on the Enforcement Committee. If you guys, did you all consider, or was there discussion about the potential to have a geographic region or area that might be currently unserved or very, very sparsely served? If we lose a PIC member, how you fill that gap if we make this the new rule?
No, we did not. That topic did not come up that I recall. We had received an application, I believe, at the time, and upon all the discussion and consideration, we just felt like, we spent some time on this recommendation, and it seemed like the best way to move forward. But to answer your question, that didn't come up specifically.
And fair enough in terms of, it may not come up often enough for it to be a concern. I just was curious.
I think one of our biggest concerns is that at the time that the applications are made, and you have one application period, the staff is prepared to go through all of the requirements in getting those approved or processed and approved. Whereas they may be focused on other areas at different times of the year, that this really could be, affect their efficiency. And so if we could, the encouragement would be to get your application in on time, and that way they have maximum efficiency in what they're doing.
And I like the efficiency. Will this create some kind of obligation or a hard, fast rule that must be followed if we found ourselves in some odd situation where we were not served in a geographic area?
No, it wouldn't create a hard and fast rule. I mean, the board is at liberty to create an exception if a need arose. I don't anticipate a problem to arise in the context of mentorship because we allow mentors to conduct mentorship via teleconference and Skype. So even if an area was particularly underserved, a respondent could get mentorship without actually traveling to the mentor.
So I'm super good with efficiency and don't want to have my voice be heard as one that disagrees with the recommendation. In fact, I like it. I just needed to have those questions answered for myself. And then I would just make one comment, since we're speaking on PIC members, that is a educational comment and that always trying to improve. We have a couple of folks that serve we have had a major change in faces on our board, and we have a couple of folks that actually serve as PIC positions that weren't really fully aware that they needed to be in our PIC training. So as we move forward and we have substitute folks move into these positions, I would encourage us to pay special attention to that and maybe even do direct outreach to those new board members that are going to be serving certain regions when that training is occurring, to be sure we get them trained up.
Yes, Madam Chair, and we have actually talked with both of those members earlier this morning to make sure that they receive the training that they will need.
And it was available, and it is available, and they have both indicated that they've reached out to do it. Just one of those always trying to get better.
And one more step, Madam Chair, on that learning and hopefully not to repeat something that turns to be deficient, is to include specific materials in our orientation training for appraiser members about their responsibility as PIC committee members, and not just to assume that, yes, it's in there and they'll read it, but actually spend some time explaining it.
And again,
yes, absolutely. And it was our oversight. I take responsibility for that.
Thank you.
As we sometimes hear from new board members, we talk in a lot of acronyms, and it's probably really confusing if you're not directly involved. PIC, Peer Investigative Committee. Appraiser members are asked to serve in an additional capacity beyond your board positions, and that is the state is divided into certain regions, and we play an additional role in the process. So that's the reason we care, and the reason the appraiser members are receiving additional training beyond what the public members are. But I'm sure you're welcome to sign in and attend any time and listen and see what we're doing. All right, that being said, I apologize for making our meetings longer, but I always like understanding. There is a recommendation by the Enforcement Committee on this agenda item. Is there action? Mr. Jeffries.
I move that the board adopt the Enforcement Committee's recommendations as presented.
Second.
A motion from Mr. Jeffries, a second from Ms. Lynch. Any conversation? All in favor?
Aye.
Anyone opposed? Motion passes unanimously. Agenda D.
Agenda item 20D, discussion and possible action regarding the Enforcement Committee's recommendation regarding access to MLS for PIC members. The board appoints PIC members, as we just heard, to assist with complaint investigations. The PIC member agreement does not require PIC members to maintain independent access to MLS for the purpose of completing a board assignment. Staff requested the board to consider whether staff can provide access to MLS for PIC members who receive such an assignment. The Enforcement Committee considered staff's request and is recommending that the board provide or direct staff to provide PIC members with access to MLS or information from MLS as needed and appropriate for PIC members to complete an assignment.
Madam Chair,
Mr. Suster.
I move that the board adopt the Enforcement Committee's recommendation as presented.
I'll second that motion.
We have a motion and a second from Mr. Jeffries. Any conversation? All in favor?
Aye.
Aye.
Anyone opposed? I'm afraid if we don't get through this soon, we're going to need coffee at the dais. So you guys hang with us. We're almost there.
Or cookies.
Yeah, arch cookies. We might have to add a little sugar. So agenda item 20E.
Discussion and possible action regarding the Education Committee recommendation regarding creating a working group to draft a 2-hour continuing education course for Texas appraisers. As part of the agency's Memorandum of Understanding, or MOU, with the Texas A&M Real Estate Center, the A&M Real Estate Center has agreed to help the board develop and write a 2-hour education course specific to Texas appraisers that would focus on state law and TALCB rules. The Education Committee considered how to implement this provision of the MOU and is recommending the board establish a working group, including the appointment of 3 to 5 subject matter experts to assist staff and the A&M Real Estate Center to develop and write a 2-hour course on state law and board rules for Texas appraisers, and make recommendations to the board regarding this education course.
The floor is open.
Madam Chair, this is an item that the Education Committee felt pretty strongly about, and I'd like to make a motion that the board adopt the Education Committee's recommendation as presented.
Second.
A motion by Mr. Jeffries, a second by Mr. Bolton. This is a shout out to Mr. De La Garza. We're going to get there someday. Any additional conversation? Mr. De La Garza is a previous chair of this board and has been many years looking to see this added. All those in favor?
Aye.
Anyone opposed? Motion passes unanimously. Agenda item number 21, discussion and possible action regarding the 2018 draft budget.
Madam Chair and members, as you heard from Mr. Black, the chair of the Budget Committee, the committee has met twice to consider this first draft of the budget. I want to explain to you some of the considerations that go into this budget, and then, of course, answer any questions that you may have. When we present this budget to you, this first draft, well, in any of our budget presentations, per your policy, we show 5 years, essentially, worth of financials. So 2 completed years, FY 2015 and 2016, actual numbers, the budget for FY 17, as well as a column that is a combination. You'll see on the top it says the data as of 2/28/2017. So we began this process in March after we closed out the month-end financials for February. So if you think about it, we have now 6 months, or this report reflects 6 months of actual expenses, September through February, for the current fiscal year that we're in, plus projecting for March through August. The remainder, the additional 6 months. So this is 6 months of actual, 6 months of projected, to get to what we anticipate will be the final actual income and expenditures through 8/31/17 in that column. That is the principal resource that we use, and then, of course, comparing it to prior years. But that's the principal resource that we use to project what our needs will be for 2018. And then in each category, you'll see we also do a single projection for 2019, and that includes, and the reason we do that is we anticipate some continuous growth in compensation and benefits expenditures, as well as our uniquely for this agency, there are major discrepancies in our revenues between even-numbered years and odd-numbered years. And so we have to show an additional year to account for the line item, which is 2 lines up from the bottom of the front page there, AMC revenue carry forward. And we'll talk more about that when we get there. And so the budget shows salaries and wages. I'm now going to comment on specific line items in budget column FY 2018. So the number that is represented there for salaries and wages is 4% more than what our baseline will be as of September the 1st. So we know where we currently are. We anticipate a few more changes, staff changes, minor ones between now and September the 1st. That will be our baseline plus 4%. That's what that number represents. And then another 4% above that for FY19 is also shown there. The employee benefits is about 38% of salary expenses. That's a very typical consistent percentage average looking back over past years. So that's what that comes out to. Most of the other costs, if you will look, you will see that they're fairly flat, except for the movement of some expenses between categories. So, for example, professional services shows a $7,000 difference between last year to the projected next year, and that includes $7,800 that was moved from that category to communication services. And if you look down about 4 lines above total expenditures, you'll see communication services, and that shows up $8,980. So the majority of that is just movement between categories. The office rent, you may recall that of course we pay rent as an SDSI agency, but we are also, our lease allows us to offset our rent against the occupancy-related elements of SWICAP, the statewide cost allocation plan. Now, I am not sure why, for a state agency which pays no taxes, that a building and for which there is no actual sinking fund for replacement, that we actually track depreciation, but we pay depreciation. The largest part of that offset there is depreciation on the building that we're in. But in any case, we're fortunate. If we didn't pay it in depreciation, we would have to pay it in rent. So those are offset against each other. And so that makes for a little bit of unpredictability between how much are we going to pay in rent and how much are we going to pay in SWICAP. So it's up slightly for SWICAP and also down, so that would mean a corresponding reduction in rent. We also have been fairly aggressively working on our document digitizing project. And of course, I announced to you, I think in February, that we were completed with the majority of that. That allows us to actually have turned back to the Facilities Commission another 695 square feet of space that we will receive credit for. We turned it back over as of May 1st, so Monday of this week. And so we'll actually receive another credit because we prepay our rent. So we'll receive a credit for that for the balance of this year and then not have to pay it in future years. I think that's all of the items that I wanted to highlight under expenses. Any question about expenses before I move to revenues?
No, sir.
Okay. So if you will look at the revenues, we have 4 categories there. License fees. If you'll notice back in our the report that Gwen gave, if you look back in the numbers of license holders, we have been consistent for many years right around 6,000. We haven't broken over the 6,100 yet. So we're fairly consistent in total number of credentialed appraisers in Texas, but there is an offset between the odd-numbered year and the even-numbered year. And so you can see that reflected if you look at the difference between the revenues received in FY 2015 in the first column and 2016 in the second column. It's about $75,000 difference between those 2 years. So our budget for 17, as you can see, moving over one column, we're actually above budget already in 2017 in terms of what we anticipate for the year. So for FY 18 projected, essentially we took 95% of our 2016 number, and we do the same for 2019. We have 95% of our 95% because we just don't vary that much. We don't have a lot of new people coming in, and we're not losing a lot of people. So we keep that. We want to be conservative. So we essentially, if it's a possible expense, we include it, and then we try to be modest on our revenue anticipation. AMCs, you can see there's a much greater discrepancy because we're very near. We started our first that program in 2012, and so the even-numbered years, if you'll look at the FY16 column, it was $845,000 of revenue, and compare that to FY15 where there was only $197,000 in revenue. And so that makes necessary that second to the last line at the bottom, which is the AMC revenue carry forward, because we have a great discrepancy in when the revenue is received. We essentially spread it evenly over 24 months. So we offset the shortage year by carrying some of the excess year into the shortage year, so that we have steady revenue over the 24-month period. And that is why if you'll look at just above the total expenditure line, you'll see, I'm sorry, it's not there. On our regular monthly reports, you see where we actually recognize that carry forward, okay, as recognized revenue if we're in one of the shortfall year. Administrative penalties are dedicated to the education fund, but the trend is down because there's far more of our complaints result in agreed dismissals of some kind, where it's really an education opportunity, unless they're repeat offenders or egregious offenders. And so there are fewer penalties imposed as well. So that trend is down. And then other miscellaneous revenue is pretty much just our exam fees, as well as some insufficient fund check fees. Putting all of that together, you'll see that we project in this first draft that we will be slightly about $15,000 in the black for this year. Going forward from today, when we close out the month of May, those financials, we will then have 9 months of actual numbers, and then only projecting 3 months, June through August. And so we'll have we'll be sharper, if you will, closer to actuals. And we will come up with a second draft of this budget. The committee will meet on it, and in July, you will all receive it in plenty of time prior to you will be able to see it. And then, of course, the budget committee will meet again at right before the August meeting, in which the budget will be considered for adoption, just like they met this morning before this one. And so one last opportunity for any tweaks, but you will have the opportunity per the policy to see the draft 2 after the committee has reviewed it in July. Any questions on revenues? Okay, or process. So if you flip to the back side, the only thing I would like to point out there is that this currently proposes, this is where we track and project our reserves. So you will see in the highlighted in tan, there are 3 reserves. The first one is the reserve for current operations and contingencies. So that shows 484,000. If you look just to the right and below that, you'll see the highlighted box there that says FY18 budget expenses of $1,535,781, and below that is the calculation of 4 months and 3 months. So your policy is to hold in reserve for operations somewhere between 3 and 4 months of total expenses. And so that sets both the cap and the floor. And so we're projecting about 32%, or 3.8 months would be held there. The reserve for educational development, there's the current balance plus what we anticipate will be added for FY17 and the total. And the third reserve, this is the only one that was discretionary or more discretionary. That's, you have in past years reserved for long-term facilities master plan a total of $740,000, and we're recommending that we can safely add $260,000 to that, bringing us up to $1 million in reserves, and still have still be very confident in our ability to meet all of our other requirements. Any questions about the reserves? Okay, so as I said, there's no need for further action today, unless you wanted to direct staff on a particular item.
I've got just one quick question.
Yes.
We do have some staff that, as I understand it, we share, if you will, in cost with TREC.
We do.
And so if TREC is making recommendations about changes in salary and whatnot, are those adopted in the assumptions
They are.
of the budget that we're seeing?
They are.
Okay.
And then I have one observation, Tony's report on demographics. As we plan into, even the next decade, as we see our appraisers retiring, I know we'll have to soon start to reflect on, a pretty significant decrease in appraisers, or else do a better job of recruiting new ones. That's just kind of seeing that report enlightened to me to what our revenues may do in about 5 to 10 years.
So as they retire, I'll just follow up that one, is everyone involved in the industry is aware of that aging trend, and fairly rapidly aging, if you will. Or consistently, not rapidly. Everybody only gets 1 day older every day, okay? There's no speed involved there. But we are, so you heard from Kristen, the AQB's proposal to change some of the requirements to hopefully encourage more folks to come into this field by sharpening those requirements to what's really essential, and then providing alternate paths to reach it, as opposed to even just 3 years ago they changed. They instituted they instituted the requirement for all credential holders, all certification holders to have a 4-year college degree. And so now they're rethinking that. So, any other questions? Okay, thank you very much.
Yes, sir, thank you. Our next item on the agenda is discussion and possible action regarding the performance review and salary of the TALCB commissioner. I'm not sure there's any action appropriate, actually, except I'd like to just visit about that. I appreciate the board members that completed a survey at the request of the board. Wanted to give you a little history and maybe the public a bit of history as well. A few years ago, to the commissioner's credit, he created a format for review. This board began filling it out probably 3 to 4 years ago. The TALCB would give the commissioner feedback. About 2 years ago, we amended our MOU with TREC, who actually votes on and makes the final determination on the commissioner's performance. But we added or amended our MOU to include the opportunity for us to have a face-to-face review by some appointed member of this board. I've been serving in that capacity. Not long ago, Avis Locash, the director of the chair of TREC, and I did meet with Doug on his previous year review. We were a little slow getting that done, but we have accomplished last year's and are quickly anticipating this year's. I mentioned to you all that the commissioner does not actually see your survey results. I will be delivering those to him in our face-to-face meeting, but I would gladly report to the public that you got high scores. We had several new board members at the time the survey was completed, and so there were several segments of the survey that were not completed. They didn't feel it would be appropriate for them to comment, or they didn't have enough experience to speak to some of the specific issues that were asked. But I appreciate very much the fact that we do get good reports and we do have positive comments. All of the reporting that was received was a quality performance or above. There were no noted numerical deficiencies at a level that would indicate needs improvement. There were a couple of narrative comments that I, again, will address directly with the commissioner when we meet, but those generally were about communication and about long-term growth and opportunities inside the organization, so positive comments. We do appreciate your leadership. We do feel lucky to have someone of your caliber driving the bus, if you will, and we look forward to, I look forward to meeting with you face-to-face and visiting with you about the specifics. And any other board members like to weigh in on the comments? Hearing none, I will just go ahead and tell you that for the record, the TREC approved a 4% raise for the commissioner at their meeting on Monday, and so that will be those are the facts. I don't believe there's any official action that we take other than just the observation that that has occurred. Commissioner?
If I might just extend 2 sentiments to you. One is thank you for the opportunity to get constructive feedback on ways to improve. I am absolutely honored to continue in this position. I've been associated with the board since 1990, well, from 99 to 2003 as a member of this board. The seat that Buster is currently in, I once sat in. So, one, I'm committed to the long-term success of this agency and board, and I have a wonderful staff. You have a wonderful staff that we've assembled and trained, and we're always looking for ways to serve the people of Texas better. And so I welcome your constant feedback on anything we can do to achieve that.
Thank you. Let's move to agenda. And we might have the record reflect that Ms. Lynch did have to leave. She had a plane she had to catch. I believe she's gone. So any future actions will not have her input. So the next item is the request for potential future meeting agenda items, which leads me to ask what the process or intent is, first with the 2 public comments that were brought to the board today. Mr. Baird, with regard to how his issues would be handled on the way his discipline is reported on our website. I believe the intention is for the board to have staff do something. Can someone speak to me about what we might anticipate? It's fine. What I understand is that there is some work in progress to broaden the potential reporting on the website. So currently, the complaint that I heard was that the website says that he was not USPAP compliant, and his order specifically says he does not agree with that, or that's the agreed order between us and Mr. Bears does not say that, so he's concerned about that. How are we going to address that?
Madam Chair, when we were first made aware of Mr. Bear's complaint, which he did bring to us directly, we set about a review of the options that are currently available. Texas law requires us to make the order available and to be public about what the basis of the order is. And so we post that all on our website. And we had created a series of categories for the basis of the order. And so we're looking at now adding additional categories which would more accurately reflect those circumstances where there have been allegations of certain deficiencies, but no admission of those deficiencies. But we still need that there is an agreed order, and so it still needs to be posted. We just need to categorize it correctly. So we're looking at creating additional categories, and I suspect we will have that, and I can commit to you that we'll have that done before the end of the month, but it may be much sooner.
So we might anticipate a future agenda item, at least updating the board on what the actions have been?
I'll be happy to tell you about it at our next meeting, absolutely.
Okay. And the second complaint, the public comments by Mr. Baker, just my observation, my personal observation is it appeared that at least his legal counsel, it wasn't apparent to me that his legal counsel understood that the payment of the $1,000 fine could have put him in a position to actually have had a opportunity for the board to have taken some action today. And so I guess I'd simply ask for the record if that conversation occurred at the staff level, or if maybe there wasn't a communication to that effect.
Madam Chair and board members, the communication did occur between Mr. Becker's attorney and staff, specifically both myself and Troy Bollier, our Director of Standards and Enforcement Services. And the comments and the request that was communicated by Mr. Becker's staff, by Mr. Becker's attorney, were not the same that he presented to the board at the meeting today. So there was perhaps some miscommunication about the steps that Mr. Becker would need to take to reinstate his license from its status of being suspended.
So that it's clear, if in fact he were to pay the fine, he would then have the opportunity, if timely requested, to potentially appear before this board and ask for additional consideration as it related to the $1,000 penalty.
Correct, Madam Chair. If he were to pay the fine, his license would become active without suspension. And at that time, if he wanted to request a refund, he could do so. This board could then add it to the agenda at a future meeting date. You could refer it to a committee for a recommendation on whether or not to grant that refund if the request is received, or you could simply take it under advisement.
And again, to be abundantly clear, the only thing that is keeping his license in current suspension status where he is not allowed to work as an appraiser is the failure to pay the $1,000 fine.
That is my understanding.
Is that correct, Troy?
That's my understanding. He's indicated today that he took the course.
You're not in possession of the proof of the 28-hour course work? Gotcha. So if in fact we've received it, then that would be the only missing item. If in fact we have not, he would need to provide proof of his 7 hours that was required, but 28 or whatever hours he took that was in excess of the agreed order. Okay. So the potential for that to be a future agenda item could exist, and I only make that as a comment. If you'll put that on a checklist of things for us to follow up on.
Certainly.
The third item I saw or made note of was a working group for the education on agenda item 20C. Is there some process to get one established, or will the Education Committee be making those recommendations for the working group?
Madam Chair, as this board has done in the past, when it has established a working group, typically the way that process works is that we put out a call for applications to serve on that working group. The applications are then collected and submitted to you as the chair to appoint members of that working group.
Perfect. I've got. Yeah, I'm fine with that. If that's acceptable to the board, I'm fine with that. I'm almost finished. Sorry, my list got a little long today. I'm not used to this. Earlier in the agenda, there was a conversation about the evaluation forms for mentors being developed by staff. Will anybody at the board ever see those, or do we also get comments from the mentors? So I'm just curious if, not that we would need official action, but will they be shown to us when you prepare them?
The surveys are sent out to the mentors and the respondents in a SurveyMonkey form via email, and we are happy to send the board copies of those questions that we ask in those surveys to both the mentors and the respondents.
Yeah, I think ultimately, as we're developing is it working right? I don't want to create, we get a lot of staff reports already, and staff spends a lot of time, I know, assembling that data, but since this is a new path that we're going down, I might encourage you that over the course of time, the combination or the accumulation of the data may be telling and helpful. Since the mentoring program is relatively new in Texas, and we are a leader in the nation, I do think we get a lot of opportunity to blaze the trail, and to the degree that we can kind of watch the program develop, I think that would be important. And then finally, the Facilities Committee. Is there a process to get someone on this board onto just a short list, or is it not timely to do such?
Previously, the chair invited volunteers from the committee, and then appointed one of the volunteers. I would suggest that we could expand it at this point to 2, if there are 2 people who would like to volunteer, or there may be more who want to volunteer, but I would limit it to 2 to be appointed to the working group.
Perfect. I think that's a good idea as we continue to develop. It's a big investment on the part of this organization. I think it's smart to have somebody with a little more intimate knowledge than a periodic update. So if you want to volunteer, let me know. If not, we'll send out an email requesting responses and then try and have some kind of answers for you, so that would potentially...
Madam Chair, just briefly, I would submit my name just temporarily until we get that email. I just want to make sure that other commitments that would allow me to participate as part of that subcommittee. But I would volunteer my name for that subcommittee.
Perfect. Thank you.
Madam Chair?
Yes, sir.
I'll throw my hat in the ring.
Perfect. As many as we can get that are interested, I'm excited about that. So please feel free to speak verbally now, or reach out to me at a later date, Kristen or Mr. Olmixon, if you guys will be sure that that's a future agenda item as well, that we'll go ahead and make those appointments on some future.
And then, Madam Chair, if I have a moment, I just have to add one more thing, and maybe I should have jumped in when we spoke about the public comments from Mr. Baer. As I understand it, we are advising staff to look into the specific request to modify the description of within the website with respect to the agreed order for Mr. Baer. And so I'm not sure if there's a motion that needs to be passed, or is that something that we just direct the staff to do? But if there isn't any, and since this is seemingly a very limited request that Mr. Bear approached us about, I would prefer to just hand this back to council to review that as part of that process without having reviewed the information inside this pamphlet.
So Mr. Bear produced about a 2-inch, maybe inch and a half document to the board, and that's what you've got on the dais now
That's
that you're saying
correct.
you'd like to get back. That's fine.
It would appear that it's just a lot of information with respect to the litigation that he described, and it's something that doesn't speak specifically to his request, and so I don't think that it's necessary and maybe not even appropriate for me to dive too deeply into that, and so I would just throw that out there. And
Okay, and I guess for the record's sake, this is a long-standing, ongoing concern. The litigation was an ongoing concern. A board prior to the seated board, maybe a couple of boards, iterations prior to this seated board, had, I'm not going to return mine. I guess that's the purpose of this comment. I am serving this board in a I guess you would call it a moderating capacity between a previous unhappy set of legal counsel and our staff, and so I intend to retain the information and review it as it relates to my history with the case.
Chair. At this time, I'd like to return the material. I have not looked at it or read any of it. I'm only aware of what Mr. Bear shared with us, and at this time, I think it's not appropriate to investigate it further, as we have instructed staff to take care of his primary concern, which was the posting on the website that he was in violation of USPAP. And at this time, I don't think that this information has any more pertinent bearing on what we've instructed the staff.
I'm going to follow suit with that as well.
Myself as well.
Myself included.
You want help? You want help you?
you got that?
Here's another one.
Thank you.
And it appears Ms. Lynch left her information behind, so I guess I'm the lucky carrier of the extra weight. I will be taking mine with me. Now, those were my list of things that needed to be future agenda items. The floor is open, or if there are other board members that have items that need to be addressed on future agendas that we need to make note of. Or anything staff-wise that you think we may need to put on our radar screen, besides the things that have been mentioned?
I can't think of anything to be added at this time.
Let's move to agenda item number 24 then, discussion and possible action to schedule future meeting dates.
So this one, I actually do have several comments to make. If you will look at page 137.
Oh, I'm sorry, before we leave the agenda item that we were just dealing with, which is essentially future agenda items, and we had every member of this board weigh in with the exception of one. The record probably should reflect Mr. Bolton has not participated in any conversation as it relates to the expanded concern. Were you given the documentations, Mr. Bolton?
I was.
Okay. And you had expressed, at least in executive session, an intent to recuse yourself as it relates to actions associated with Mr. Bear's case. Okay. I just thought the record might need to reflect that. I don't know if this is the appropriate place to do it, but since everyone else had weighed in, I wanted to give you that chance. And now, I apologize, Commissioner, you can go back to our future meetings.
All right. So back to, if you look at page 137, the calendaring. There are a couple of items that we'll deal with the most specific first, and then they'll be general. So you'll see that our next meeting is currently scheduled for Friday, August the 18th. This room is not available on that date. We were bumped, and so we would recommend that we move that to, What was the recommendation? The 7th?
Monday, the 14th, which was the previous date of the commission meeting that we already had the room reserved.
Perfect. So we're recommending that we move that to Monday, the 14th of that same week. We had the room available that day, and the commission moved their meeting to Monday, the 7th. And so it becomes available now on Monday, the 14th. And so that's our recommendation for the next meeting date. And then I'll explore some other recommendations here shortly, but does that meeting date work for the majority of the board?
What about, well, it will, but I've already planned my summer pretty much running up on the 18th, but as I look at my schedule, the 25th, I mean, I prefer a Friday personally. I'm not saying I can't make a Monday, but I would prefer a Friday date if it's possible. That's why is there any big football game the weekend of the 25th or something that?
I'm going to guess yes.
The weekend of the 25th, 6th, and 7th would be the UT move-in weekend.
Oh,
before
there won't be
classes
any
start.
rooms.
Yeah, so not a good
Sorry.
time to do it then. Okay.
But otherwise, does the 14th work for the rest of the board?
Works for me. Yes, sir.
Okay.
I think I can move what I have.
I'll try to juggle some things around as well.
Okay, so the one thing we do need to do is assure ourselves that we will have, some potential for a quorum. So if it is problematic for you, speak up so we can figure out while we're assembled what we might do. Okay, hearing none, Commissioners, set it for the 14th.
Okay. So that brings us to a much more broad-ranging discussion. It has become increasingly difficult in the city of Austin to get hotel rooms on Thursday night at the state rate. Almost all, especially downtown, almost every weekend there's something going on, whether it's football games or concerts or there's lots and lots and lots of different kinds of activities, races, foot races, bike races, car races, all kinds of things. Football games, we talked about. So there are, the hotels have basically told us that Thursday, Friday, and Saturday, there will be in the future, no state rate rooms available. That makes it significantly more expensive for us to continue to have Friday meetings. Because without the state rate, we're looking at an increase of a minimum of $100 over for each and every room night that we're doing over the current state rate. And so it is our recommendation, and I want the board to consider this seriously, that we consider permanently moving our meetings to Mondays, because Sunday night is probably the easiest night to get rooms. So for those who plan things in conjunction with a weekend, it would just be at the end of the weekend rather than the beginning of the weekend. We currently have this board has, in its most recent history, had workshops in conjunction with with November meetings, so that's an additional day, as well as we're planning for the, as we did this past year, the summit, the Residential Realty Summit, to continue in February's, and so that will be, that's one other concern as well. The more that we pile onto the weekend, the more expensive that actually becomes. And so we're suggesting that if we move it to Mondays, we're going to take the next step, which is to talk to other agencies and then try to negotiate with the nearby hotel, the nearest one, the Hampton. If we can, they basically said, if you can guarantee us 100 nights, now we'll talk to you about about preference and blocking off rooms and that kind of stuff in a year, and at the state rate. So those are things that we would like to do to keep our expenses in check. But we realize that it's your time. You are volunteering your time to do this. And so it's our recommendation that we at least have a discussion about permanently moving to Mondays, moving our meetings to Mondays.
I'll weigh in real quick then. I enjoy and love serving on this board, and I'm glad that I get to do it for another 6 years. And I like the fact that it does fall on a Friday. It works really well for me, and in this particular instance, right now, I'm going to stay throughout the weekend. I enjoy being here in Austin. It works much better for me, and that's my preference. I'm certainly don't want to be obtuse, though, but I would say that it is certainly not a problem for me to pay out of pocket. You know, whatever the state, if we kept it on a Friday, and if that is going to be a problem, that's kind of the way I look at it right now anyway. It's not a big deal. I'm not real sure what I'm getting charged at the Hampton right now and what I'm going to get reimbursed for, but I'm just going to turn it in, and whatever I get reimbursed back for is fine. It's not going to be a big deal to me. If I don't, whatever I get reimbursed for is great. That's not a big issue for me if it's state rate or whatever. So just from a logistics standpoint, Fridays work better for me, but if it's decided that we want to move it to Monday, I will sure be here, and I'll find a way to make it work as well. But for the record, I prefer Fridays.
I'm of no feeling strongly one way or the other, and if Monday does work better, well, I'd say we need to move in that direction, notwithstanding what Clayton has offered to the board. But I think it makes sense in a way that you're on the long and the short end of the weekend, so
I was not taken in this year's NFL football draft, therefore my Mondays and Sundays are available.
Well, we'll be rooting for you the next go-round.
And Martha's not here. I'd be curious to see what she has to say. But, as far as folks that live here, I completely get that, what you're saying. I don't know. Well, you're in Lubbock, I guess, so it doesn't matter to you. Alejandro, what do you?
I am agnostic on the matter. I live in San Antonio.
Okay.
So, traffic-wise, it might be preferable on a Friday if I judge based on what I experienced this morning, but I don't know. Otherwise, I really don't have an opinion on the matter. I can do either day.
And also, there's something else that just came into my head. I go to church every Sunday. I mean, I try to make that a bit, and after that, I go to Midland Country Club and have brunch.
He's a routine man.
I am. I'm a creature of habit, and if I am at home, I am at church on Sunday. I mean, just literally religiously. So that's really not a good day for me to travel. So I'm gonna say I want to stick with Friday, if at all possible.
Operationally, for me, Mondays are more problematic because I do kick off my week with my staff meetings, and Mondays, if we are involved in a trial, that is a time they will definitely more likely need us than on Fridays as giving testimony. That being said, as it relates to my staff on a quarterly meeting basis, I don't think that's insurmountable. They can figure out how to do without me, or I can FaceTime them early in the mornings. I will just say that Mondays have the potential to be a bit more conflicting for me, to the degree that we can identify the dates in advance so that I can anticipate and block. It would be helpful. So leaving it up in the air is probably more problematic for me than making a date change. Mr. Bolton, Joyce, either of you have any comments?
I like Wednesday afternoon.
Okay. Well, we'll consider that. Joyce?
No, I like the Friday format. I'm like you. Monday's more problematic, but I can make that work if I need to.
Joyce, does it matter to you?
No, I think Clayton's just looking for an excuse to come down to Austin on a Friday, but I am agreeable to whatever is best for the board.
All right, so if we were to move forward with the expectation that Monday makes the most sense, when would we have some feeling for what the potential date would be? Would it be November that we'd be having the next board meeting beyond the August meeting?
We looked at November 6th, I believe, and it's available. We have tentatively blocked the room for Monday, November the 6th.
Have you looked? Okay.
And that would close out our working calendar year, not our official year, right? But that would be the last of the 2017 meetings, as best we know.
That's correct. And then February, that date has not yet been set.
Would that try and correspond with the summit? Is that not?
We're going to try and course, but we haven't set the summit date either.
Okay.
Although of course, that was on a Friday. The summit was on a Friday, and we moved the meeting to Thursday. There is, I want to say that the date has already been set for ASC visit, but I can't.
Yes.
I apologize for not knowing that off the top of my head.
Yeah, no worries. I guess communication is what will be helpful to us to the degree that you learn those dates. If you can give us advance notice, we'll make adjustments. So, Mr. Black, I didn't take a vote, and I certainly want you to feel like your voice was heard. Do you think I should actually have an official action? Should we vote on a Monday date, or just move ahead with the process we have at the moment?
Well, Martha's out my way, and she's not here. I know it's. Okay. I'm kind of curious to hear what she has to say. I think we've all voiced our opinion at this point.
All right, so let's do this. Let's agree that at least the August meeting will certainly occur on the Monday. It doesn't sound like we have much choice. We're conflicted out of that one.
I would agree.
We're probably leaning towards you need to be making your voice heard as it relates to the November meeting date, since we don't have anything booked yet.
And Madam Chair, the only other concern for a November meeting is the holding of a workshop, because typically we do that the afternoon before the meeting. So the question would be, if there's a need to hold a workshop, would that be a Monday, Tuesday format?
So, yeah, that's going to be, when you start coming in on a Thursday afternoon, right? And having the workshop Thursday afternoon, me staying Thursday night, and having the board meeting Friday is one thing. Coming in Monday for an all-day meeting and then hanging over and losing another workday is probably a bit more problematic for me, and I don't imagine our staff wants to begin to volunteer to come in on Sunday and do our workshop. So we may think about whether that November meeting might actually need to be more towards the end of a week if we're able to accommodate it.
Is the concern with one particular hotel, or is it just?
No, it's all hotels.
All hotels.
All the hotels.
They're not going to
downtown.
honor the state rate.
They're not.
So how much budget impact does it have? If
Well,
we make
at-
a quick, if we do a quick math?
Sure. At a minimum, it's $100 per night per room, right? So it's.
How many of
So
them?
if the current configuration of the board is 4 travelers that typically take at least one night.
Gotcha.
At least one hotel night.
So we're talking about somewhere in the neighborhood of $1,600 to $2,000 if we assume that it's an extra $100 every single time, which that sounds like the assumption we need to make based on what the staff is reporting to us. So worst case scenario, at a very minimum, we probably should also address that.
Sure. I mean, that's the minimum, assuming only 4 travelers and only one night per quarter.
Sure.
The only other question that I wanted to raise was we have not yet, we have had 2 back-to-back November workshops. And I'm all for continuing those. But we could potentially come up with a different format in terms of having a workshop on a Monday morning and a truncated meeting on Monday afternoon and still leave it to one day. But that's just, because we do this, we don't have committee, we don't necessarily need to have committee meetings in November on the morning of the meeting date. So we probably need to have a workshop to talk about meetings and workshops.
Yeah, I think
Well, as with regards to reimbursement, my company pays the expenses. It sounds like Clayton's going to pay his, so you're really only dealing with the potential of
Yeah, and I
two
really don't
people,
think
so
that
it's not
that was the
significant.
point of making
Yeah.
the public comment, is it's not $20,000, right? And it's not necessarily even anything.
So it really doesn't matter to me, but from a
I
financial
feel-
standpoint, it's not
I feel the same way.
too big a drain.
It's not so much driven, from my perspective, by that either.
I would say that we're talking about a very insignificant amount percentage-wise versus what the total budget is, and even is not a massively significant amount of what you projected as a budget surplus. So I think this is an expense that if it proves to be more problematic to have meetings on a Monday, which it sounds like logistically it just kind of doesn't fit very well. Friday seems to work well, and I would say that we would just maybe need to adjust. Clayton, you're running the budget committee. Find the money.
There's the challenge. So for August, for sure, we're going to be on a Monday meeting. We'll continue the conversation as it relates to November.
Just to give you some advice, and we will confirm the availability for this room, Friday the 10th, that is a UT home game weekend. So we might have more problems getting hotels on that weekend. The board's regular meeting would occur normally on Friday the 17th, which is an away game for the University of Texas. So, you might consider November 17th as we consider November 6th as well.
Okay, so November 6th or 17th, block both of those for now. We'll see how well Clayton can both lobby and find money.
That's right.
I don't want to keep him from going to church. That's my big deal.
Well, it's not, I mean, this weekend, obviously, I'm going to miss church. I'm staying throughout the weekend, but it does, if I don't, I'd say it's about 50-50 for these meetings. I'll stay for the weekend and it's nice, or just literally I'm on the road headed back right now, but.
Okay. I think we've got good enough direction at least to get you through the August meeting, and we'll continue the conversation. Is there any additional business to be taken up by this board? If not, we'll consider ourselves adjourned at 2:45.
Thank you, board members.